MacDonald. Second reading what day?
Friday the 15th of March.
Friday the 15th of March. Thank you. Presentation of Bill. Richard Ford.
Military action, parliamentary approval bill.
Second reading what day?
Friday the 26th of January.
Friday the 26th of January. Thank you very much. We now come to the 10-minute rule motion. Neil Hanvey.
Thank you, Madam Deputy Speaker. I beg to move that leave be given to bring in a bill to amend the Scotland Act 1998 to transfer the power to legislate for a Scottish independence referendum to the Scottish Parliament, to provide that such power may only be exercised where the Scottish public had demonstrated its support for holding such a referendum, to provide that no such referendum may be held sooner than 7 years following any previous such referendum, and for connected purposes. I'm standing up for the right for self-determination. I'm standing up for our territory. I'm standing up for our people. I'm standing up for international law. I'm standing up for all those territories, those small territories and peoples the world over. These are the words of then Prime Minister Margaret Thatcher, recounted from her Downing Street years memoirs. She goes on to say, the principle of self-determination has become a fundamental component of international law and is enshrined in the UN Charter. That principle she spoke of, the principle of self-determination of peoples, was enshrined in the UN Charter when Prime Minister Winston Churchill signed the 1941 Atlantic Charter. Any notion that Scots freely entered into the Union by an act of self-determination has no credibility whatsoever. In 1707, a majority of Scottish parliamentarians may have been persuaded, but the people were never consulted. The Acts of Union 1707 between England and Scotland created the Kingdom of Great Britain, establishing a single political entity, yet preserving the territorial, legal and institutional integrity of each partner country. The UK's constitution is not codified in a single document, so the question of whether the Acts of Union can be unilaterally dissolved by one party is not clear. However, the accepted position hitherto is that the Union is a voluntary association of equal partners and that Scotland has an unquestioned right of self-determination. Scotland's distinct constitutional tradition is best expressed by Lord Cooper in the case of McCormick versus Lord Advocate, which says the principle of the unlimited sovereignty of Parliament is a distinctively English principle which has no counterpart in Scottish constitutional law. And in the pleadings of the Honourable and Learned Member for Edinburgh South West in her prorogation case to the UK Supreme Court, it was noted that the 1707 Parliamentary Union between England and Scotland may have created a new state, but it did not create one nation. In recent years, the UK state has steadfastly refused to acknowledge or honour the principle or the democratic wishes of the Scottish electorate. According to distinguished academic and legal practitioner in international law, Professor Robert McCorquodale, the people of Scotland are distinct within the UK and have a right to self-determination. And as the people of Scotland are a people for the purposes of the right to self-determination, the choice of the means to exercise it is for the people to decide, not for the state. These are not obscure or arcane points of law, they are precise and purposeful, and according to Professor McCorquodale, such treaty obligations are binding under international law on all states. The question of whether the ancient nation of Scotland should be an independent country once again continues to be the subject of much debate. In short, with current support sitting at 50% across the population and above 70% among younger people, the matter is far from settled. It is entirely proper for any country to review such important matters because Scotland will only become independent as and when a majority of the people of Scotland choose that path. This demands the use of a democratic mechanism that is constitutional and satisfies international legal precedent. This bill seeks to standardise and codify such a requirement in line with the motion passed by this House, which endorsed the principles of the 1989 Claim of Right and which acknowledged the sovereign right of the Scottish people to determine the form of government best suited to their needs. At that time, the Claim of Right was supported by every political party save the Tories. In particular, Liberal Democrat MPs such as Ray Mitchie and Charles Kennedy were forthright in their support for the principle of Scottish sovereignty. They were following a Home Rule tradition in that party which never for a second disputed Scotland's right of self-determination, albeit they thought Scotland should choose a form of federalism rather than independence. It would be unfortunate then today if, already having deserted their historic commitment to the European cause, the Liberal Democrats were to follow that by deserting their historic commitment to respecting Scotland's national rights. This morning, the Honourable Member for Edinburgh West called this bill, which favours neither one side nor the other, divisive and unnecessary, when it is anything but. It is in fact both liberal and fundamentally democratic. The effect of this bill should be uncontroversial for every member. It merely establishes in law an equivalent mechanism to the principle already conceded by the UK Government in relation to a border poll in Northern Ireland. Firstly, that the power to legislate for a referendum requires a democratic mandate from the Scottish public to do so. Since 2014, that criterion has been met in successive general elections to the Scottish Parliament, most recently in 2021, where a majority of MSPs were elected and a majority of votes were cast in favour of a manifesto commitment to deliver an independence referendum. Secondly, this bill states that no such referendum may be held any sooner than every 7 years after any previous such referendum. Should members of this chamber deny Scotland her legitimate claim on self-determination, then it will have put beyond doubt that the voice of the people of Scotland is not welcome in this place, and a new approach must be considered. This bill offers both remedy and root. It places the power to decide firmly where it belongs, in the hands of the people of Scotland, and it does so by transferring the power to hold a referendum on independence to the Scottish Parliament. It is a parallel initiative to that being led by my Alba Party colleague Ash Regan MSP in the Scottish Parliament. Ms Regan has brought forward a draft bill that would allow a referendum to be held to ask the people of Scotland if they think that the Scottish Parliament should have the powers to negotiate and legislate for independence. Its purpose is to consult the people of Scotland on their opinion on extending the provisions of their Parliament to hold such a referendum, a proposition supported by expert legal opinion of Aidan O'Neill KC. Both proposals have at their heart the democratic imperative that Scotland's political destiny must be in the hands of the people of Scotland, not in the hands of a Westminster Parliament or the Supreme Court. How does the behaviour of the UK Government or the repeated espoused position of the opposition party constitute access to meaningful political process, as claimed in the recent UK Supreme Court judgment? In the aftermath of the 2014 referendum, the All-Party Smith Commission agreement was signed by all of Scotland's main political parties, SNP, Labour, Tory and Liberal Democrats, and it stated, "It is agreed that nothing in this report prevents Scotland becoming an independent country in the future, should the people of Scotland so choose." While each have failed to deliver on that commitment, this bill provides a necessary, equitable and democratic mechanism for the people of Scotland. In 1889, in this place, the equality of the UK partner countries was asserted by a Liberal MP, William Ewart Gladstone, when he said the following: "I am to suppose a case in which Scotland, unanimously or by a clearly preponderating voice, were to make the demand on the United Parliament to be treated not only on the same principle, but in the same manner as Ireland. I could not deny the title of Scotland to urge such a claim."
Good old Gladstone.
John Major, when Prime Minister, said of Scotland, "No nation could be held irrevocably in a union against its will." It is increasingly apparent that this is not a union of equals. The UK is willfully subverting the will of the people of Scotland by denying them their established human rights as enshrined in the UN Charter and international treaty obligations, which the UK state entered into freely. At the opening of my speech, I cited the words of Lady Thatcher, but she went further. The Scots, being a historic nation with a proud past, have an undoubted right to national self-determination. Should they determine on independence, no English party or politician would stand in their way, however much we might regret their departure. Whether I like it or loathe it, we are in this union, and I hold that it is incumbent on every MP elected on an independence ticket to explore every option with courage and conviction. Today, this chamber faces a choice. Affirm that this is a voluntary union of equals, or tell the world that Scotland is a mere possession to do with as you wish. This bill is a necessary condition for securing Scottish democracy, and I commend it to the House.
Yeah. I call Christine Jardine to speak for no more than 10 minutes in opposition to the motion.
Thank you, Madam Deputy Speaker. And can I congratulate the Honourable Member for Kirkcaldy and Cowdenbeath on securing this debate, this motion, but also on his knowledge of Liberal political history. I have to confess, though, that my overwhelming emotion, my overwhelming sentiment on hearing of this debate was, oh, not again. Surely this has been settled not just by the Supreme Court ruling, but the repeated occasions on which the people of Scotland, myself included, other MPs here, the electorates of several constituencies, and the majority of people at the last general election and in the referendum made it clear that no, we cannot be held in a union against our will. But our will is to stay. So here we are. On the anniversary of the Parliamentary approval of the Act of Union in 1707, going over the same nationalist argument again and again. The argument which has been rejected in the referendum and rejected at the general election. This could and should be a day when the people of this country might expect their elected representatives to be considering the importance of what has gone before as a result of that act. Considering what we have achieved and what we have built and what we can continue to build and improve upon as part of the union. Because, as the Honourable Member said, as a Liberal and a Liberal Democrat, I do fundamentally believe in Home Rule for Scotland. I do fundamentally agree that the United Kingdom needs to change. And I do agree that the people of Scotland deserve incremental increases in power. But that is because I believe in a federal United Kingdom. I have said so on numerous occasions and will continue to do so. I would also point out that in the past 45 years, there have been 3 referendums on Scottish future, Scottish political future, the Scottish people's future, and the state of the Constitution. Every single one of them was facilitated by the United Kingdom government. And on every occasion, the Scottish people have benefited. As a result of the second one, we have devolution. And surely even those devolution sceptics can see the good that has come from our Parliament. The benefits we have seen not just in Scotland, but from devolution in Wales, and the great changes we've seen in Northern Ireland, and let's not forget of devolution to the Assembly in London. The third referendum on independence in 2014 was facilitated by the UK government when they felt that the Scottish Parliament and the Scottish parliamentary elections had proven that there was a mandate. I know this because, and I have a declaration of interest to declare, I worked on that referendum. And as a result, we have more devolved powers. We have come so far since the turn of the new century in devolving powers in this country. So it is closer to the people most affected by it. It would be dreadful to undermine that, to throw the baby out with the bathwater for a separatist argument. And let's be clear, that is what some colleagues want to do. It is not a secret that I disagree fundamentally with my colleagues on the Alba and SNP benches about independence and where Scotland should be heading, particularly at a time when what is required of us in this place is to work together to solve the ills that are blighting people across these aisles. And I would repeat, in doing that, the UK government is not a block on more devolution. They have worked to enable it. And whatever nationalists might tell us, independence is not an answer to our problems. It is not even the question that most people in Scotland want to raise. That question is about inflation, about interest rates, about the cost of living. They constantly, in my constituency, ask me about instability across the globe and what we are going to do about those issues. And yes, they want change, but they want a different government. They want a different approach. What they do not want, and what they regularly tell me they are fed up hearing about, is separation. They are tired of the negativity of their world and their children's world becoming smaller because of mismanaged governments and ideological decisions. They want to address the problems with our education system in Scotland, with our NHS in Scotland, with our public services in Scotland, all of which have declined during the period of nationalist government when the only thing they prioritised was independence. And we are suffering, and we do not want to do that anymore. But perhaps if the nationalists lifted their heads from their ideological manifesto about separation, and perhaps if they listened a little more to the people of Scotland and stopped taking the support for granted, they would know that themselves. They would know that they may not like this particular government, and there are times when, frankly, I agree wholeheartedly with the people of Scotland. They don't like this particular government, but they see an opportunity for change coming in the next few months. Perhaps that is why the nationalists are putting new impetus into their cause, because they see that there is an opportunity for change coming, and that people will choose to change the government rather than the constitution. The problem that is before us is that the United Kingdom, we all know, is not perfect. Of course it isn't. What governmental system is? It needs reform. We need to move forward, I believe, to a more federal system. But what we do not need is more division, more rancour, at a time when we already have a list of problems in this country longer than any of us would like. This proposition before us would do little to address those very real problems faced by my constituents and everyone else in Scotland. It would, as I say, be just one more division, more arguments, same old grievances. It's time to move on. Accept that the will of the Scottish people, as expressed regularly, is to remain in the United Kingdom and work to improve it and the lives of all of the people of the United Kingdom. The Scottish people have expressed their will. No, they cannot be, as we have all said, held in a union against our will. But our will is to stay in that United Kingdom. And I would ask this House not to waste any more time on an argument that the Scottish people have settled and will do so again at the next general election.
Question is that the honourable member have leave to bring in the bill. As many as are of that opinion say aye. Aye. The contrary, no. No. Division, clear the lobby. Two minutes now. Yeah. If they're not putting in tellers, the divisions are.
They're over there.
question is that the honourable member have leave to bring in the bill. As many as are of that opinion say aye. Aye. Contrary, no. No. Tellers for the ayes, Jonathan Edwards and Carol Monaghan. Tellers for the noes, William Ragg and Sir Robert Buckler. the doors. Order.
The ayes to the right, 48. The noes to the left, 228.
Thank you. The ayes to the right, 48. The noes to the left, 228. So the noes have it, the noes have it. Unlock. Order. The clerk will now proceed to read the orders of the day.
Safety of Rwanda, Asylum and Immigration Bill, Committee.
Now. Order. Order.
Safety of Rwanda, Asylum and Immigration Bill.
I remind members that in committee, members should not address the chair as Deputy Speaker. Please use our names when addressing the chair, or Madam Chair, Chair, Madam Chairman, or Mr Chairman are also acceptable. Lots of options. That's my name. I mentioned that to start. We begin with Amendment 45 to Clause 2, with which it will be convenient to consider other amendments to Clause 2, Clause 2 stand part, amendments to Clause 4, Clause 4 stand part, new Clause 6 and amendments to Clause 9, which relate to Clause 2, as set out in the selection paper. I call Alison Thulis to move Amendment 45.
Thank you very much, Madam Chair. I move the amendments in my name and the names of my honourable colleagues. The SNP have brought forward amendments to this appalling bill, not because we believe really that there are improvements which could be made to it, but because that is the limitation of the process that we have in front of us this afternoon. This bill is irredeemably awful in each and every provision, in every clause, and with the intent behind it. And it will not work. Like the hostile environment that came before, the Nationality and Borders Act and the Illegal Migration Act, which only got royal assent 180 days ago, It will fail to reach its objectives because it fails to engage with reality. The more I hear from government benches on this issue, the many Home Office ministers who have come and gone before, I can only feel that they just do not understand why people seek sanctuary on our shores. They are astonishing in their ignorance and baffling in the lack of effort that they put into understanding. And one of the reasons, those reasons that people do come to the UK, is the UK's now clearly defunct reputation for fairness and the rule of law, which this bill comprehensively shreds. The Committee for the Joint Council for the Welfare of Immigrants have highlighted the impact that all of this has had on people that they deal with. They have mentioned a Kurdish client who fled Iran under a death sentence by the Iranian government. On arriving in the UK, he was issued a removal notice to Rwanda. He said, "The reason I came to England is that I knew I would be safe in the UK, and I was trapped by the smugglers. When I received the news that I would be sent to Rwanda, it felt like death again to me." At the Supreme Court ruling, this person was relieved. He thought he was going to be safe, and now he is going. He has had the rug pulled underneath him yet again.
Point of order.
This does seem very much a second reading to me. It would be very helpful if the Honourable Lady could direct the amendments in which we're interested to hear what she's got to say.
It's actually amendments and clause stand part.
Yes.
So that just give a little wider scope than perhaps the right honourable gentleman realised. Alison Toulis. Oh.
Thank you very much, Dame Rosie. I'm glad the honourable gentleman has had your advice on the subject of this debate. Madam Deputy Speaker, to put this into context, I sit in front of people every single week in my advice surgeries and listen patiently to the stories of constituents who come to see me. I have often read their Home Office statements. They have been through trauma. They have made perilous journeys at unimaginable cost. They have been tortured and they bear the scars, both physical and mental. They have seen their relatives murdered. They have run rather than be forcibly recruited into an army that would kill and rape their loved ones. They have been victims of trafficking and slavery. They have been unable to hide their views of their identity from those who would persecute them. They have seen the stable life that they have built crumble before their eyes. They never planned to be sitting on a random Friday morning in a community centre in Glasgow in tears before a member of some other country's parliament. They don't understand why this UK government treats them so poorly, disbelieves them, forces them to wait, prevents them from working, keeps them apart from the only loved ones they have left, and I can't comprehend it either. If you can tell me why the government treats people so poorly, yes, I would.
I'm grateful to the Honourable Lady for giving way, and I've been listening with interest to the compassion that she is expressing. But could she tell me how many illegal asylum seekers per head of population Scotland is accommodating, and how many illegal asylum seekers per head of population England is accommodating?
Gentle should inform himself, because there is no such thing as an illegal asylum seeker in the first place. He can sit down, he's made his point. These fellow human beings from Afghanistan, from Syria, from Yemen, from Libya, from Iran, from Iraq, from Ethiopia, from Eritrea, from Sudan, from China, from the DRC, from Cameroon, Tamils from Sri Lanka, Ahmadiyas from Pakistan, all of these and more have given me just the tiniest of insights into their lives. It is a privilege to know them and to help them as much as I can as their MP. Glasgow is home to many different nationalities, and it gives me great pleasure to attend community events and celebrate the diversity that enriches us, to learn to dance the Atan Swain, to teach Afghan Scots in return to do the Gay Gordons and the Dashing White Sergeant, to be called up to sing very badly alongside the wonderful Maryhill Integration Network Joyous Choir, to share the most delicious food from Africa Alba and Africa Future, to play football as badly as I sing in the refugee football tournament that is held every year in Scotland, organised by Councillor Abdul Bastani.
I don't want to try your patience, but Clause 2 is about the safety of Rwanda, and this has nothing to do with that at all.
Thank the honourable gentleman for his point of order. He can leave it with me, honestly. And I do think it's rather discourteous to keep disrupting the debate. I will keep a close eye, I can assure him, and if the Honourable Lady veers off track, I will make sure she gets back on track. But can we just not have the debate disrupted constantly like this? Alison Toulis.
Thank you, Madam Deputy Speaker. And perhaps if you would like to come along to listen to Olivia Ndoti and the women at the Women's Integration Network in Glasgow, maybe he'll hear from people from Rwanda, because this government grants asylum to people from Rwanda, because that country is not safe. I don't believe that anyone who supports this awful bill can do so knowing the people it will affect. To lay out in such cruel terms that they would remove the rights of our fellow human beings because all they did was seek sanctuary and safety. It undermines our obligations under international law and in the need for individualised protection guaranteed, for example, under the Anti-Trafficking Convention. That this government seeks to declare a country safe by legislating for it to be so is an absolute affront. Our Amendment 48 simply seeks to change safe to unsafe, because for every decision maker to be forced to declare any country safe, regardless of the facts in front of them, regardless of their own knowledge, regardless of circumstance, flies in the face of the justice and the rights that the UK is supposed to stand for. It is illogical. Amnesty has called this treating fact as false.
Amendment 45 in particular. That amendment, as she's just said, would permanently in this legislation designate Rwanda as an unsafe country. And she's just complained about having to designate decision makers the other way. So, one, what is the difference? Secondly, isn't that offensive to Rwanda? Thirdly, isn't that worrying to the 100+ refugees from Libya who the UN recently settled in Rwanda? And under what circumstances would she then agree to legislation which recognise Rwanda, again, as a safe country?
I believe it's fundamentally unwise to recognise countries as safe in perpetuity, because things are unsafe. This amendment highlights the illogicality of this bill. Neither of these things should be legislated upon at all. And to make the point around the Libyans that are being transited through Rwanda, they're not settling in Rwanda, they're being transited through Rwanda to other countries like Canada, for example. I want to make some progress. I know that he will want to contribute later on, and I want to touch on what the UNHCR have said about this. They have reviewed the updated UK-Rwanda scheme, and they say, and I quote, "It maintains its position that the arrangement as now articulated in the UK-Rwanda Partnership Treaty and accompanying legislative scheme does not meet the required standards relating to the legality and appropriateness of the transfer of asylum seekers and is not compatible." It is not compatible with international refugee law. Equally, this bill does not have any kind of sunset clause. It doesn't have a set of circumstances by which it can acknowledge a change in the situation in Rwanda. This is foolhardy and it is bad legislation. The clauses which talk about mere monitoring of this situation do not go far enough, and it's a prime example of the incompetence of this legislation and how it cannot really be made to work. There has been ongoing tension, for example, with the neighbouring Democratic Republic of Congo, where recently elected President Tshisekedi has been quoted in relation to Rwandan-backed M23 rebels, saying, "If you re-elect me and Rwanda persists, I will request the Parliament and Congress to authorise a declaration of war. We will march on Kigali. Tell Kagame those days of playing games with Congolese leaders are over." So I ask members opposite, what happens to their precious treaty and to this legislation should this situation escalate? None of us want to see that, but it could happen. What would happen, more importantly, to anybody that the Home Secretary had sent to Rwanda in the interim to this unsafe situation? They would not be able to bring them back. They would be stuck in a situation of conflict. It is beyond me how members opposite and former ministers, members of the legal profession, could sign up to amendments shredding the rule of law and human rights. Our amendments 46, 47, 48, 49 and 50 are an attempt at the very minimum reinstate the powers of our courts and tribunals to do their work. They are the people qualified to make these decisions and do so, for the most part, with great diligence. Their services are stretched and there's much more that could be improved were the UK government not chucking away hundreds of millions of pounds at distractions like the legislation they bring here today. They have also recently published their consultation response on safe and legal routes following the Illegal Migration Act, and it offers nothing. It offers no change whatsoever, no safe and legal routes that are new and would help to resolve the situation. The Refugee Council have presented a credible alternative to this, and the Minister could not be less interested. Madam Chair, I honestly don't know what to say about the amendments of the former Minister, the member for Newark, and his cabal. It sickens me that they would treat people this way. Surely the only way in their minds that they can justify treating asylum seekers this way is that they consider them to be less, that they do not matter and they can therefore be shipped off as if they were some kind of inconvenient waste, stirring up fear and hatred of people who only came here to ask for our protection. This is real lives, not some political game. And for the focus on the Tory psychodramas in the benches opposite, this is real people and real people's lives. On these benches, we say that they are humans just like us. Shame on all of them. Madam Chair, I would like to have seen much more from the Labour Party in opposing this vile legislation. They concern themselves today simply with an amendment around the risk of refoulement, not the tawdry practice in itself of offshoring asylum seekers. Labour's new Clause 6 merely seeks to monitor this shoddy deal, not to dismantle it. Last week, they would not be clear if it was the principle of Rwanda or just the costs that they found problematic. So I asked them, the Shadow Minister, would he revoke this legislation? Overruling courts, treating people as if they were less than human, not entitled to the rights that we all expect. These are dark days, Madam Chair. This is not normal, and nor should it become so. On the SNP benches, we will fight this rotten bill all the way, today, tomorrow, and any opportunity we get, not in our name.
Hear, hear. The question is that Amendment 45 be made. Robert Jenrick.
Thank you, Dame Rosie, and I rise to speak in favour of the amendments in my name and that of my honourable friend, the member for Stone. Dame Rosie, a single question, at least on our side, hangs over this debate. What works? It doesn't matter whether this is the most robust piece of immigration legislation we've ever done. That's not relevant. It doesn't matter whether this is a suitable compromise between this faction or that. That might be a noble aim, but that's not what we're here to do on behalf of our constituents today. What matters is, does this scheme work? And why does that matter? It matters because illegal migration is doing untold damage to our country. It is costing us billions of pounds. It's exploiting tens of thousands of people. It's leaving a trail of human misery across Europe, across North Africa and beyond. People are drowning in the English Channel and will continue to do so month after month. We have to fix this problem. And we in this House have the power to do so and the responsibility on our shoulders. The question is, are we willing to do it? I will give way to the honourable gentleman in a moment. Let me finish my point. The current bill doesn't work. And the test of whether it works is not can we get a few symbolic flights off in the months ahead with a small number of illegal migrants on them. The test is can we create the kind of sustainable deterrent that we set out to achieve. The sustainable deterrent that my right honourable friend, the member for Whittam, set out to achieve when she secured this groundbreaking deal with Rwanda. The kind of deterrent that protects not just this country for generations to come from the scourge of illegal migration, but the whole continent of Europe. Because I can tell all honourable and right honourable members, having spoken to almost every interior minister and immigration minister, not just in Europe, but in Egypt, in Tunisia, in Morocco, in Turkey, they all ask, when are you getting this policy up and running? Will it work? And they want it to work, because they know if we can create a sustainable deterrent, we will stop people coming, we will secure Europe's borders, we will save lives. And in an age of mass migration, this is one of the most important challenges that we have to face. I'll give way to the right honourable gentleman.
Sir Chris Bryan.
I completely agree with him about one thing. I don't think this bill will work. I don't think it will work if it has the amendments that he's tabled included in it either. And that is because I think he and I come to a completely different position as to the nature of the deterrence and whether it would work at all. Because it seems to me self-evident that there must be an enormous deterrent if you have to get in a tiny boat, risking your life as a pregnant woman with children beside you, having paid thousands of pounds to a vile, despicable people trafficker. Why? What evidence does he have that this plan, gimmick, is any more deterrent than that?
Here, 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 here.
If the right honourable gentleman were right, then hundreds of thousands of people wouldn't be making that very journey every year. There are millions of people in the world who want to make this journey. There are thousands of people in France seeking to pay people smugglers to come to our country. The only way you will stop this is if you break the people smugglers' business model once and for all. So it is clear, beyond doubt, that if you come to this country, you will be detained and swiftly removed to Rwanda or to another safe country. And where the right honourable gentleman is wrong is he, like the Labour front bench, believe completely erroneously that you can arrest your way out of this problem. Yes. Well, the National Crime Agency don't support them in that contention, and I have not seen any evidence that that will work. Nobody who's looked into this problem believes that these fungible and complex gangs that stretch across Europe and beyond, who import boats for next to nothing from China and Bulgaria and Turkey, can just be arrested out of their existence. Everyone says the same thing: create a deterrent. That is what the Rwanda policy does. I won't give way again to the right honourable gentleman. Let me move forward and speak more directly to our amendments, because that's the purpose of today. The amendments that have been brought forward in my name and that of my honourable friend, the member for Stone, in 4 groups, 2 of which will be heard and discussed today, 2 tomorrow, seek to address the evident flaws of the bill. And they represent the last opportunity for us to get this policy right. Let me speak directly to the one that is in my name, and my right honourable friend for Stone can speak to the one which he leads. Mine speaks to individual claims, and this is a point that I have made time and again. All my experience at the Home Office teaches me that every single illegal migrant coming to this country will try every possible way to avoid being removed. We know that. That's what they do today. It's human nature that people would do this. You have to legislate for human nature, not against it. And every legal representative and lefty lawyer will try everything they can to support those claims. We see it every time. Experience teaches us this. Now, the bill does improve the situation. The bill makes it tighter, but only in respect of the general safety of Rwanda, not in respect of an individual's circumstance. So I'll give way to the honourable lady in a moment. But so as night follows day, every migrant will say, Rwanda may be generally safe, and I believe it is, but it's not safe for me. And that is one of the central intellectual incoherences, as the government's own lawyers have said, at the heart of this bill. It envisages that Rwanda is generally safe, but for a range of unspecified reasons, foresees that Rwanda will not be safe for others. And of course, as we've seen in the past, one person will mount a successful challenge. That will create a precedent. Every legal representative and NGO like Care for Calais will then school everyone to make exactly the same challenge. And time and again, we will lose these cases in the courts. So the bill in that respect is legally flawed, but it's also operationally flawed because of that. And let me explain to those who are not as well versed as, understandably, those of us who've been ministers in this field are. We only have 2,000 detained spaces in our immigration removal centres in this country. On a single day in August, 1,200 people arrived illegally on our shores. So in a weekend, all the detained capacity in the whole United Kingdom would be consumed. So when you're considering whether this bill works or not, see it through that lens. We have to get people out of the country within days, not months. And the operational plan behind this bill foresees that people will take months to be removed from the country. So what will happen is that our detained capacity will be filled, people will then be bailed to hotels, they will then abscond and never be seen again. And within a single week in August, this scheme will have failed. Now, that matters for the country, of course it matters for the government, it matters for trust in politics and Westminster, because we will have told people it was going to work, knowing that it will not work. And it matters for all those other European countries who want this scheme to succeed, to protect our borders. Well, I'll give way to my honourable friend.
I'm grateful to my honourable friend, and he's making a good case for deterrent, but I fear a bad case for his amendments. As the Home Affairs Select Committee found out, when the Rwanda scheme was announced, there was a big surge of people in Calais trying to regularise their status in France because they didn't want to risk being sent to Rwanda. So deterrents do work. But does he not acknowledge, he's just said this is the last opportunity to get this right, that there is a very large chance that his amendments would make this bill unworkable, not least in the eyes of the Rwandan government, in which case we have no deterrence, so therefore what is the alternative then?
Question head on. I've known the honourable gentleman for a long time, and he wasn't born yesterday. That argument is not a plausible one, in my opinion. The argument that the Rwandan government would walk away from this scheme was raised not just at the 11th hour, but
1 minute to midnight.
1 minute to midnight. It's predicated on the belief that the government of Rwanda would walk away from a scheme on the grounds that it might conceivably fall foul of the European Convention on Human Rights, which Rwanda is not itself a party to, and where the only reason we would fall foul of the European Convention of Human Rights would have been because of conduct in Rwanda itself. Yeah. I don't find that a plausible argument, I'm afraid. And if it were the correct response, why then pilot a bill through Parliament where on the very front page it says the government cannot attest to the fact that the bill is compliant with international law? Why would the Prime Minister say that he's willing to ignore foreign judges when his own legal advice says that that's in breach of international law? And why would we pursue a policy which the UNHCR has just said yesterday is, in their opinion, in breach of international law? I think this is not a plausible argument from the government. I think it was unwise for the government to solicit that press release from the government of Rwanda. I don't think that we should cast blame on the government of Rwanda, because I think that they are honourable people who want this scheme to work, and I have the highest opinion of our interlocutors in Rwanda, and it's for that reason that I want to do what we said we would do when my right honourable friend created the scheme, which is work with them in good faith to get the job done. I won't give way at the moment. Let me make some more progress on explaining the amendment, if I may. The way that flights will work when this scheme commences is not under the Illegal Migration Act that we passed last year at all. The first several months of flights will be through a group of individuals who my right honourable friend, the member for Whittam, and her officials at the time selected when the Rwanda policy was first devised. Those individuals have been in the United Kingdom for months, or years, many of whom we've lost contact with, none of whom can be subject to the protections in the Illegal Migration Act. So even if you believe that the serious and irreversible harm test within it is a very strict one, and I'll come to that in a moment, that won't apply to the flights that will go off in the months ahead. It may not apply to any flights that go off before the next general election. So if you want those flights to be full of illegal migrants and there to be a deterrent effect, I think you need to support the amendments that I've set out, which create that strict approach. When we do, I'll give way in a moment. When we do come to those individuals who are subject to the Illegal Migration Act's strictures, the government's contention is that the serious and irreversible harm test is a very high one. I don't think that's right. I think the Supreme Court's judgment lowers the bar. The revealed preference of the judiciary is to be generous towards illegal migrants. It is to make this scheme difficult to operationalise. And as this is the last legal opportunity or legislative opportunity for us to tackle this issue, I suggest we get it right and we narrow the opportunities for the judiciary to intervene, or else we're going to find that these flights are symbolic flights with very few individuals on them at all. I will give way.
I'm grateful. I wanted to touch on something that you mentioned earlier on with regard to whether it will work at all. He's very often gone on the record as saying about the Albania scheme, which has been very, very successful. There's now 90% fewer Albanians coming across. In the year to September last year, 2,749 illegal migrants were returned to Albania. They didn't require these amendments, and the law that we currently have allowed them to be returned, and I don't remember hearing about any appeals from those people. So on that basis, and this bill is stricter than what we currently have, why won't it work if it already works on the Albania scheme?
Well, I've heard that argument advanced before, and of course I'm proud of what we've achieved with the Albania scheme, but I think that is judging two quite different propositions. The Albania scheme is taking somebody who is in the United Kingdom and asking them to return to their home country, a European country, a highly developed country. It's a very different proposition, I'd say, to my honourable friend, than asking somebody, in fact, not asking somebody, enforcing that they should be removed from the United Kingdom to a third country which they do not wish to go to. Also, as he may know, very few small boat arrivals have been removed to Rwanda, to Albania. Almost all of those individuals who have gone to Albania have been foreign national offenders in our prisons, time-served FNOs. They've been individuals who have voluntarily chosen to return to Albania, and those who've been in the United Kingdom for a long time. The success of this scheme rests on taking people off small boats, detaining them for very short periods of time, and then removing them swiftly to Rwanda. For the reasons I've just set out, I think that's extremely unlikely to succeed at any scale in the way the bill is currently structured. I'll give way to the Honourable Lady, and then I'll conclude my remarks, if I may.
Caroline Lucas.
I'm grateful to him for giving way and would just point out that people arrive in small boats because legal routes have been blocked. But when it comes to his amendment in particular, Clause 4 of this disgusting bill already provides a very, very limited route for individuals to challenge their removal to Rwanda based on their individual circumstances. Yet my understanding is that the Right Honourable Member is seeking to go even further to override individual legal protections. Even decisions which contain errors would not be open to challenge under his Amendment 22, as I understand it. How on earth is that fair or just or justifiable?
Well, on her first point, we've had this argument many times before, but she's completely wrong. This country is one of the world's most generous countries for supporting those in need around the world. And since 2015, we have issued more than 500,000 visas on humanitarian grounds, more than at any time in our history. On the point she makes about my amendment, it's not correct to say that we wouldn't enable people to challenge on their individual circumstances, but they wouldn't be able to be suspensive. So individuals would arrive in the UK, and within days, which is critical to the success of the scheme, they would be removed to Rwanda, where they could bring forward claims as they may wish, but they wouldn't block the flights, and that is critical, without which the scheme will simply not succeed. What we will also say, I won't give way to the right to remember, what we will also say in this amendment is that there are very narrow grounds in which individuals would not be put on flights, ones the Home Office are very used to dealing with through fitness to travel requirements. And that is a concept that's well known and understood, and I'm certain would work. So what does the amendment do that's different? It narrows down the reasons why which individuals could make claims and makes the scheme legally and operationally workable for the first time. Now, Dame Rosie, Sir Roger, Damascene conversion. We've tried to be constructive in bringing forward this and other amendments. The Prime Minister set a test to me and to anyone who shares my determination to tackle this issue. And that was as follows, that he would accept any amendment, whether it strengthened this bill, if there were respectable legal arguments in international law in their favour. Now, we can argue about whether that test is the right one. Personally, I feel very strongly that there are times when contested notions of international law should not surpass either parliamentary sovereignty or, above all, the interests of our constituents. And border security and national security are the prime responsibilities of any government. But that was the test. We've met the test. We instructed a very eminent lawyer, John Larkin, KC, former Attorney General of Northern Ireland, to provide us with an opinion. The opinion says that each and every one of the amendments in my name and that of the member for Stone are compliant with international law. Unless the goalposts have been shifted by the government, I see no reason why the Prime Minister and the Minister couldn't accept these amendments and enable us to strengthen this bill once and for all. Sir Roger, I'll conclude by saying this. At the outset, I said that there was one question hanging over this debate, what works. There is a further question. How much are we actually willing to do to stop the boats? Yeah. How are we willing to take on the vested interests, balance the trade-offs, take the robust steps that will actually work? The only countries in the world that have fixed this problem, latterly Australia and Greece, have been willing to take the most robust action. Are we? Well, I am. I want to stop the boats and secure our borders. This is a difficult issue, but we're not a parish council struggling with some kind of intractable legal issue. We're a sovereign parliament. The power is in our hands. We have agency. The law is our servant, not our master. I would urge all right honourable and honourable members to support the amendments in my name and those of my honourable friend, the member for Stone, and create a scheme that actually works. That's what our constituents expect of us. That is the promise that the Prime Minister has made to them and the whole country.
Hear, hear. Opposition front bench, Stephen Kinnock.
Thank you very much indeed, Mr Chairman. I rise to speak in favour of Amendments 35 and 37 and new Clause 6, tabled in the name of the Shadow Home Secretary and myself. But may I just start by reminding the House and anyone watching at home that the Labour Party is opposed to this bill in its entirety, for the simple reason that we are opposed to the Rwanda scheme in its entirety. We have been absolutely clear that we need to stop the Conservative small boats chaos, and we need to fix our broken asylum system. But those aims can only be achieved by way of measures that are based on common sense, hard graft and international cooperation, as opposed to headline chasing and government by gimmick from the benches opposite. Now, the benches opposite like to accuse us of opposing everything that the government is doing to stop the Tory small boats chaos, but that is simply not the case. We on these benches fully support measures such as the deal with Albania, because that is the sort of sensible, pragmatic action that can make a tangible difference. And we've repeatedly made our support for this course of action crystal clear, if only the benches opposite would care to listen. But the Labour Party will never support any proposal that is unaffordable, unworkable or unlawful. And Mr Chairman, I will goodbye.
Honourable friend for giving way, and would he agree with me that the government is being extremely neglectful with the public purse by throwing money at the Rwanda scheme that simply will not work?
Well, my honourable friend is absolutely right. It's quite remarkable that a party that used to pride itself on being the party of fiscal rectitude is throwing £400 million of taxpayers' money at the government of Rwanda for precisely nothing. The only thing they've got so far is they've sent 3 Home Secretaries to Rwanda, but not a single asylum seeker. And Mr Chair, the Rwanda plan is all of the above. It is unaffordable, it is unworkable, and it is unlawful. It's unaffordable to the British taxpayer because a truly staggering £400 million of our taxpayers' money is on the way to the Rwandan government without a single asylum seeker landing in Rwanda. It's unworkable because we know that the Rwandan authorities are only capable of less than 1% of the 30,000 who crossed the channel in small boats in 2023, according to the Court of Appeal. In order for a deterrent to be effective, it has to be credible. And surely even the most ardent supporter of this policy would acknowledge that such a tiny chance of being sent to Rwanda is ever going to deter someone who has risked life and limb to cross continents to escape from persecution and violence.
The Foreign Office recently admitted that hundreds of Afghans eligible for resettlement have not been brought into the UK. They exemplify the need for safe and legal routes. And is it not the case that those are exactly the people who are risking life and limb because they cannot get the legal and safe routes that the government should provide?
Well, the Honourable Lady is right, and a case in point, of course, is the Afghan schemes. The Arab scheme has more or less collapsed. The ACRS is not working at all. And which nationality is always in the top 2 or 3 to be crossing on the small boats? The Afghans. It's pretty straightforward. So we oppose the Rwanda policy because it's not a deterrent, it's a distraction. Far better, as the Shadow Home Secretary and myself and others have set out many times in this chamber, to redirect the vast quantities of taxpayers' money that are being wasted on the Rwanda scheme into a new cross-border police unit and into a new security partnership with Europol, which can smash the criminal smuggler gangs upstream. I will give way.
I'm very grateful. I think he's making a really important point about how we need to be cooperating much more intensively with the law enforcement agencies across Europe. The brutal fact is this: these gangs are putting people into boats that were made for rivers, not sea, in treacherous conditions. I mean, who in their right mind would go in one of those dinghies in the English Channel right now? But people are being forced to do that by these gangs. We need to smash the gangs, and we can only do that by working with our colleagues across Europe to make sure that we bring this to an end.
My honourable friend is absolutely right, and if we accept that international cooperation with our European partners and allies has to be at the heart of the dealing with the gangs, as he so eloquently sets out, the possibility of that cooperation is fundamentally undermined when we have a government that is flagrantly prepared to break international law, which should underpin the trust that is a prerequisite for all of this cooperation to happen. So this cooperation, based on joint working and intelligence sharing with our partners and allies, is only possible if Britain is deemed to be a trustworthy partner. And that brings me to the third reason for us opposing the legislation that's before us today and for opposing the amendments that have been tabled by so many on the benches opposite. Because, Mr Chair, we find ourselves in an utterly extraordinary position. We find ourselves debating a government policy which has been found to be unlawful by the highest court in our land. Amendment 35, which I'll come to shortly, reflects that very fact. And we find ourselves confronted by a government that is seeking to legislate for an alternative reality. Because whilst ministers appear to believe that they can pass a bill which determines that the sky is green and the grass is blue, that does not make it so. I will give way.
Has it escaped the honourable gentleman's notice that there was one claim that was dismissed by the Supreme Court judgment on Rwanda, and that was in Iraqi, the case of ASM. And the reason for it is very simple, and the court made this crystal clear in paragraph 144 of its judgment, that the issue in question was undermined, as far as that claimant was concerned, by clear and unambiguous words in an Act of Parliament. In other words, the sovereignty of Parliament prevailed.
I thank the honourable gentleman for his comments, but the point with the sovereignty of Parliament, of course Parliament is sovereign, and of course we in this place are sent here to make laws, but we must make those laws with restraint. We must make those laws whilst respecting the judicial function. The separation of powers is fundamental to our identity as a liberal democracy. So whilst he does very often talk about the sovereignty of Parliament, it is absolutely vital that his comments must always be founded on the principle of the checks and balances that the separation of powers gives us. I will give way.
Well, Tim, just to tease out a little bit more what Labour policy is on that specific issue that he referred to, is he ruling out any consideration of this House determining to overturn the wrongful convictions of hundreds of sub-postmasters simply because that would be setting a new precedent in the relationship between this House and the courts?
Well, that's an interesting one. I didn't have it on my bingo card today to be talking about the sub-postmasters scandal. Look, Parliament is free to legislate in any way that it wishes, but it has to do so taking full recognition of the view of the courts. And I note that a number of eminent legal experts have raised some concerns about the government's proposed approach on the sub-postmasters. We have to see precisely how the detail of that looks, and it is our duty in this Parliament to scrutinise that very carefully and to ensure that we're not setting dangerous precedents. What I would argue is there is no doubt whatsoever that the bill before us today is a deeply dangerous, profoundly dangerous precedent because it seeks to directly overturn the findings of the highest court in our land. And I would argue that that is a toxic approach, Mr. Chair. I'll give way to this.
Very grateful to the Shadow Minister for giving way. Has he not seen all the comments and budget lines that this government has put out, stating that it is cooperating extensively and fully with continental countries over trying to crack down on this awful trade which is leading to deaths in these small boats, and that the proof of that is that money is sent to France in order to help them with their tasks, and there is no evidence that they're not cooperating?
I thank the honourable gentleman for his comments. The cooperation with France is to be welcomed. The problem with it is it's too far downstream. What we need to see is far better cooperation upstream, which is about sharing data, fixing the issue with the databases. My right honourable friend, the Shadow Home Secretary and the Leader of the Opposition visited Europol recently to come forward with very practical and detailed plans around getting the data sharing right. And that may actually then address the issue that the number of prosecutions of criminal smuggler gangs is going down on this government's watch. The number of returns and removals has gone down by 50% since 2010. So I think it's, again, we go back to this point about let's put more energy and resources into the pragmatic, sensible things that can actually make a difference, as opposed to being distracted by this madcap Rwanda scheme. So, Mr. Chair, it's a mark. I will, if I could just make a little bit of progress. Mr. Chair, it is a mark of a liberal democracy that courts are independent of Parliament and the executive. And we on these benches believe passionately that this separation of powers is a fundamental and immutable element of what makes us proud to be British. So we on these benches are not only opposed to the specifics of this bill, Mr. Chair, we are also deeply troubled by what it represents in a broader sense. And I will give way.
Christmas period, the Labour front bench anonymously briefed The Times to say that they would want to pursue an offshore processing model. Is that correct, that it is his position and that of the Shadow Home Secretary? And if so, why would they want to do something which is known to be more expensive and less effective because you have to bring everyone back to the United Kingdom one way or another, and so you create no deterrent whatsoever, but one wouldn't want to move forward with a scheme like Rwanda?
Well, I thank the former Immigration Minister for his comments, and I must say I did enjoy opposing him and working with him on some occasions, and I thank him for his comments. What I would say is that if you look at the Ukraine scheme, that is an example of offshore processing. Those applications were processed in Poland before they came to our country. Look at the Hong Kong scheme. There are plenty of ways of doing upstream processing, offshore processing, and to coin a phrase, what matters is what works. And what is absolutely clear is this Rwanda, and it's difficult to imagine any scheme that could be more expensive than this one. But I'm going to make some progress. What I would cite is the view of the Bingham Centre for the Rule of Law and countless other legal experts who have stated that this bill is contrary to the rule of law because it amounts to a legislative usurpation of the judicial function. It is an assault on our country's constitutional conventions, which require the legislature to respect the essence of the judicial function. Moreover, there is a staggering hypocrisy at the heart of this bill when you consider it in the context of the treaty that has been signed with Rwanda. Because the purpose of that treaty is to bind the Rwandan government into respecting the rule of law, and in particular the principle of non-refoulement. But how on earth can ministers hold the Rwandan authorities to account on these matters if they themselves are so blatantly and egregiously failing to practice what they preach?
The Honourable Gentleman, it is a little disingenuous to liken the Ukrainian scheme. The only criteria for the Ukrainian scheme is you had to be Ukrainian and come from Ukraine. He just mentioned enforcement, and he said that it had gone down. So up to the end of November 2023, Home Office Immigration Enforcement arrested over 246 people for people smuggling into the UK, and there were 124 convictions. And that is in addition to those arrests and convictions which have happened in the continent. So on what figures that he's just claimed were those figures a decline?
There's been a 30% drop since 2010 in the convictions of criminal smuggler gangs, and there has been a 50% drop since 2010 in removals. I'd be very happy to write to the honourable gentleman with the clear details of that fact. We've got the receipts. So, Mr. Chair, it is against this fundamentally flawed and farcical backdrop that we seek to modify the legislation that is before us today. Our amendments are an attempt at damage limitation, an effort to moderate the most egregious aspects of this nonsensical and counterproductive bill. Our Amendment 35 acknowledges that, in November of last year, the Supreme Court upheld the Court of Appeal judgment. It ruled unanimously that the Rwanda policy was unlawful because there were substantial grounds to believe people transferred there could be sent to countries where they'd face persecution or inhumane treatment if Rwanda rejected their asylum claims, a practice known as refoulement. The reason for these concerns relate to an issue that I first raised at this dispatch box back in April 2022, when the Rwanda plan was first announced. And that is the fact that when Israel signed its deal with Rwanda in 2013, many of the asylum seekers who were sent from Israel to Rwanda were routinely moved clandestinely to Uganda. And in 3 cases, refoulement to Eritrea via Kenya was only prevented by the UNHCR intervening. Little wonder that the Israeli Supreme Court ruled the scheme unlawful in 2018 and it was closed down. In December, the government signed a treaty with the Rwandan government which says that refoulement is prohibited and says anyone removed to Rwanda from the UK must be allowed to stay in Rwanda. Indeed, the only country to which people can be transferred from Rwanda is the UK, which under the deal must also accept some of Rwanda's most vulnerable refugees and offenders sent back from the country. This fact in itself tells a story, Mr. Chair. The fact that the UK government and the Rwandan government have agreed that Britain might need to take some Rwandan refugees is a stark admission of the fact that Rwanda is not a safe country for many people. Indeed, since the first £120 million payment by the British government to Rwanda, 6 Rwandans have been granted safety and refuge in the UK. And then there is the tragic fact that ministers are simply too afraid to address that in 2018, 12 Congolese refugees were shot dead by Rwandan police for protesting against food shortages. Mr Chair, our Amendment 35 therefore permits British courts and tribunals to recognise and deal with the specific risks of refoulement associated with Rwanda by removing the relevant text in Clause 2 of this bill. Likewise, our Amendment 37 makes it clear that decision-makers must be able to take the risk of refoulement into consideration when processing asylum claims. The bill designates Rwanda as a safe country and therefore makes clear that every decision-maker must conclusively treat the Republic of Rwanda as such. It states that the bill does not permit a decision-maker to consider any matter, claim or complaint to the extent that it relates to the issue of whether the Republic of Rwanda will or may remove or send the person in question to another state in contravention of any of its international obligations, including in particular its obligations under the Refugee Convention. Yet, as the government has previously acknowledged, the facts on the ground can change, and therefore it must be acknowledged that decision-makers should be able to make their own judgments based on the latest court rulings. So we see no reason not to let decision-makers do their jobs and make decisions based on all the knowledge available to them as the situation evolves, as opposed to the frankly absurd idea that Rwanda can be defined as safe in perpetuity. I turn now to our new Clause 6. The new treaty states that Rwanda is committed to addressing concerns that are laid out in the Supreme Court judgment, including refoulement. New Clause 6 would simply help to ensure that Rwanda can be held accountable on its treaty commitments by placing the monitoring committee for the Rwanda Treaty on a statutory basis and by placing conditions on when the classification of Rwanda as safe can be suspended in accordance with the material conditions and or non-compliance with obligations under the Rwanda Treaty. As things stand, the government could vary the operating principles of the Monitoring Committee without it being possible for such changes to be challenged in our domestic courts. Our new Clause 6 therefore addresses this unacceptable position by placing the Monitoring Committee on a statutory footing, thus making it justiciable and thus, by definition, more transparent and more accountable. We see no reason why members opposite and across this House should oppose the principles of transparency and accountability upon which our new Clause 6 is based, and we hope they will join us in the I lobby later. Turning briefly to the amendments put forward by members opposite, I would point out that even one of their own colleagues, the chair of, I believe it's called the One Nation Group, has described many of these amendments as authoritarian and a betrayal of conservative values. And he's right, Mr. Chair. The bill in its current form is already an assault on our reputation as a country that upholds the separation of powers and the rule of law. And the majority of the amendments tabled by the benches opposite would take us even further away from those basic democratic principles. So let me be clear. We on these benches will be proudly voting against the amendments that are being promoted by the benches opposite, because the government's Rwanda policy is unaffordable, unworkable and unlawful, because this bill is an affront to the values that we hold dear, and because we will always stand up for the separation of powers, for the rule of law and for ensuring that we can stand tall in the world.
He's very kind to give way a second time. I've listened to him carefully, and I don't have an answer to one of the central questions of the debate. Is the government's view that Rwanda is a safe country? What is the view of the Labour Party? Is Rwanda a safe country? I think we would all be interested to know, and I know the government of Rwanda would be interested to know the Labour Party's position.
Well, I thank the honourable member for that intervention. I don't think I could have made it any more clear that we believe in the rule of law and in the judicial function. And when the Supreme Court of our land rules that it is not safe to send asylum seekers to Rwanda, we on these benches agree absolutely with that position. Mr. Chair, we've seen some pretty bizarre stuff emanating from the benches opposite over the decades. But when the history books of the last 14 years are written, their psychodramas over this Rwanda policy will surely take centre stage. Just think of the astonishing amount of government time that's been ploughed into this unaffordable and unworkable nonsense, when ministers and officials could have been focused on the design and delivery of the sort of sensible, practical measures that I mentioned earlier. And just think of the vast amounts of political capital that the Prime Minister has squandered on a policy that he doesn't actually believe in, and that his Home Secretary has privately poo-pooed, if you'll pardon the pun, Mr Chair, and that has left his leadership in tatters. The legislation before us is a sham. But in the interest of damage limitation, I urge members to get behind Labour's amendments today. And of course, most crucially, I urge members to vote down this bill at third reading and get behind Labour's plan to deliver the security partnership, the cross-border police unit that will smash these criminal gangs and defeat the people smugglers and will stop the Tory boat chaos once and for all.
Sir William Cash.
Mr Chairman, we want the bill to succeed. We want it to work, and we want to do what our voters want. But at present, it does not. Clause 2, as it stands, does not work, and that is why I shall put my Amendment 10 to a vote, supported as it is by well over 60 members of Parliament. Clause 2 of the bill needs to be amended with clear and unambiguous words and with a full notwithstanding formula, not the one that is currently on offer. This formula has been used throughout our legislative history for hundreds of years, but most recently it's been enacted in our most important domestic and constitutional legislation without opposition, namely in Section 38 of the Withdrawal Agreement 2020. The sovereignty of the Crown in Parliament is democracy and is described in the leading case by the great Lord Bingham, our greatest modern jurist, as the bedrock of our Constitution. Democracy delivers the wishes of the voters who elect us through the legislation that we pass as Acts of Parliament, and it is this democracy for which people fought and died. Nothing could be more important to their daily lives, including illegal immigration, and that is why this issue is so important. But it is also important to stress that genuine refugees are fairly protected, as this country always has, as in the case of Afghanistan, Hong Kong, and so forth. Yesterday's YouGov poll makes it clear how strongly people feel about all this. It is a legal, constitutional, and also, therefore, essentially a political problem. The reason why sovereignty is so fundamental is that the courts recognise that they have a duty to interpret, adjudicate and obey the laws and acts made under that parliamentary sovereignty, where legislative words are clear, express, explicit and unambiguous. Therefore, the use of a comprehensive notwithstanding formula, as in my amendment, would ensure that we make this bill work in line with the intended purposes of the bill and not be frustrated by claims of international law or other contrary law. This bill in its current form will not prevent, as everyone knows, further ingenious individual claims followed by further Supreme Court decisions. The recent Supreme Court judgment itself on the 15th of November 2023, as I pointed out in intervention, makes my very point. It shows that the words in the Immigration and Asylum Acts at that point in time were not clear and unambiguous, but, and this is vital, it seems to have escaped many people's notice that one of the claimants, ASM and Iraqi, had his claim dismissed in that very judgment because, in the words of Lord Reid, the President of the Supreme Court himself, I quote, "In any event, the principle of legality does not permit a court to disregard an unambiguous expression of Parliament's intention, such as that with which we are concerned," I say to the honourable gentleman on the front bench, "with which we are concerned in the present case." This was emphatically because the retained EU Law Act and related immigration legislation was so clear and unambiguous in that case as to require the court to dismiss the claim of the Iraqi precisely as a matter of parliamentary sovereignty. This Rwanda, of course.
Did my honourable friend, who's doing a wonderful job as always in these areas, see the recent briefings that seem to come from the government that they're expecting a lot of cases under their law and they're going to provide a lot more judges to do it? Aren't they telling us that it isn't going to work?
That's right. I'm afraid to say that that does appear to be the inevitable inference to be drawn from the statements that have been made. And the worry is that unless the law is completely clear and unambiguous, there's going to be more trouble. And if this bill was to be passed with clear and unambiguous words, they wouldn't be needing the judges that they seem to be wanting to employ, nor for that matter all the fees that the lawyers will accumulate as a result of taking part in some very spurious cases. So, as I've said, the Rwanda judgment is in line with all previous judgments by preeminent jurists in recent generations, and I mentioned but a few: Lords Denning, Lord Reid, Lord Hoffman, Lord Bingham and others. Months ago, I sent the Prime Minister a 7-page memorandum, each line of which set out breaches of international law in almost every jurisdiction in the world, including even the EU itself, the United States, France and Germany, where clearly apparent breaches of international law have occurred and without international sanctions. As to the Vienna Convention, what really matters is whether the internal domestic law is of fundamental importance in the national interest. And this illegal immigration law manifestly is. We have in the UK a dualist system of law, where the sovereignty of Parliament is fundamental to our rule of law and cannot be trumped by international law, by the opinions or conventions of the government legal service, or, speaking as a former Shadow Attorney General, if this be the case, even by an Attorney General. We have a dualistic approach to these matters, in which domestic law and international law are seen as independent of one another. And in the recent Miller 1 judgment, at paragraph 57, it states, "Our dualist system is a necessary corollary of parliamentary sovereignty. It exists to protect Parliament, not ministers." Furthermore, as Lord Hoffman made so clear in R versus Lyons in 2002, the courts will have regard to the words of the statute, not the treaty. This is because we have no written constitution defining the internal status of international law within the United Kingdom. As Lord Bingham has said, international law is, quote, complementary to the national laws of individual states and in no way antagonistic to them. Close quote. International law is not supranational, unlike European law. British courts cannot deem a statute unconstitutional. Under our constitution, it's the King in Parliament who legislates and not His Majesty's government. I thought they'd learned that in the Civil War in the 1640s. And the court does not require to have regard to functions of government when interpreting the law. A statute, even one arising from an international treaty, will always prevail over a rule of international law. Lord Hoffman, in the case of R versus Lyons, 2002, stated, and I will quote what he says, I can't improve on it, "It is firmly established that international treaties do not form part of English law and that English courts have no jurisdiction to interpret or apply them. It is not the treaty but the statute that forms part of English law, and English courts will not, unless the statute expressly so provides, be bound to give effect to interpretations of the treaty by an international court, even though the United Kingdom is bound by international law to do so. The sovereign legislator in the United Kingdom is Parliament. If Parliament has plainly laid down the law, it is the duty of the courts to apply it, whether that would involve the Crown in breach of an international treaty or not. Nothing could be clearer." In Bradley and Ewing's authoritative book, Constitutional and Administrative Law, it is clearly stated that the legislative supremacy of Parliament is not limited by international law. The courts may not hold an act void on the ground it contravenes general principles of international law. Indeed, the Labour government in 1998 specifically reaffirmed the sovereignty of Parliament in relation to its Human Rights Act, saying it would not seek to quote, would not seek to transfer power from future parliaments to the courts because it would confer on the judiciary a general power over the decisions of Parliament and would draw the judiciary into serious conflict with Parliament. Their own white paper stated, I quote, "There is no evidence to suggest the judiciary desire this power, nor that the public wishes them to have it." I do wish the honourable gentleman on the front bench was listening to this, because it's about the Labour Party. This still applies today. Indeed, under paragraph 53 of the House of Lords Constitution Committee report on the 18th of January 2023, the committee accepts that UK domestic law can, and I quote, diverge from obligations agreed by the government under an international treaty and ratified following the CRAG procedures. Parliamentary sovereignty means that Parliament could legislate to ensure that domestic law differed from the requirements of a treaty. And in paragraph 54 they state, Parliament, having enacted legislation that is not compliant with UK's international obligations, the courts are bound to apply that law. And further in paragraph 58 they go on to say, parliamentary sovereignty, and I quote, means that Parliament can legislate contrary to the UK's obligations under international law. So there we have it. And I should add that many members of that committee, like Lord Faulkner of Thoroton, are certainly not Conservatives nor Brexiteers. So there we are, we're all agreed. So in our unique unwritten constitution, our sovereignty patently prevails over international law, which is, I say by way of contrast, for example, with that of Germany. And what happens there? Article 25 of their written constitution, which I've taken from an established work on public international law, states as follows. These are the words of the very constitution in Germany. The general rules of public international law are an integral part of federal law. They shall take precedence over the laws and shall directly create rights and duties for the inhabitants of the federal territory. Similar provisions, for example, apply under the Dutch Constitution, Articles 65 and 66. So what does this tell us? That there is a dualist system and that some countries take a view which is different from ours. We just happen to be on the right side of the fence. Similar provisions may be applied by specialist international lawyers, and they may seek to make out that international law in this country prevails over clearly explicit words in acts of Parliament and parliamentary sovereignty. But there is no House of Lords or Supreme Court case which supports this proposition. I give way.
Very much enjoying his speech as always, and he gave the example of Germany, but even as for obvious historical reasons, they've imported principles of international law into their own domestic constitutional law. For example, the German Supreme Court, the Federal Constitutional Court, still reserves its right to be the final arbiter whether, for example, European Union law is incompatible with the German Basic Law.
Well, I'm extremely glad that my right honourable friend has made that point, because actually I had the disobliging necessity to read some of the Supreme Court judgments from Germany, and believe me, sometimes they run to nearly 1,000 pages for the very simple reason that they're struggling to find something which will support the German people as compared to some of the rules of law which are applied more generally from on an international footing, which causes them so much trouble. So, as I've said, the European Union, and the point my honourable friend just made makes my point for me, is itself in a complete mess on this issue of illegal migration, and we are well out of it. It still has the Charter of Fundamental Rights, which we excluded in our withdrawal agreements, and legal changes to its immigration law, all of which will require hotly contested constitutional changes and referenda in its member states. They're going to be bedevilled by referenda, by constitutional change. I fear they will not succeed. Very many are up in arms about compulsory quotas and fines for non-compliance being imposed upon them under the new Asylum Pact, Immigration and Asylum Pact, and which was passed by a majority vote. And it's noteworthy that recently the French government defied rulings of the Supreme Court regarding the deportation of an Uzbek national, but cannot apparently trace him as ordered by their own Supreme Court. by reference to the barracking I'm receiving at the moment, I'd simply point out the relevance of this is that we're talking about our constitution, which can solve the problem, and theirs, which cannot. I certainly will.
Of course, he's making a compelling argument about the difference between this country and those abroad who failed to take back control when we did. And he will know that constitutionalists from Dicey to Denham, from Lord Wolfe to Lord Somerton, agree with him that this place is supreme and the supremacy of Parliament is at stake as we debate his amendment and this bill.
Well, I have to say with all humility, if I may, that it's not so much that I agree with them or that they agree with me, but that this is the law of our land, this is the rule of law as it applies to the United Kingdom. And it is a tribute to the British people that they took that decision in 2016. As I said to the Prime Minister in December's Liaison Committee meeting, he himself can be a world leader on this illegal migration issue, not only in the EU, but also in the United States, in Canada, in Australia, every country in the world. The International Refugee Convention, among other conventions, is seen as requiring reform. And in Europe, it is clear that they need to change the European Convention on Human Rights, as well as EU immigration law, and the European Union voters are voting with their feet. This bill, nor the amendments are in breach of the present Refugee Convention, as this convention does not prohibit states outsourcing asylum claims and settlements to a third country. Similarly, the European Convention does not prescribe how its rights and freedoms are to be secured. Moreover, there has been, and I quote the words, a fundamental change of circumstances in the increase of illegal migration, criminality and the deaths that these have incurred since the convention was created. So it is clear that the currently described obligations, as they're put, must take account of this change. We have to keep up with the times. And mass immigration is one of the main issues before all nations. So what is more important? Passing a bill that works and is consistent with the democratic will of the people and the national interest, our constitutional arrangements and parliamentary sovereignty, or supporting the uncertainties and vagaries of international law. Far from diminishing our international reputation, we now have the opportunity to enhance it by demonstrating that we can deal with illegal migration by making this bill work through our own parliamentary sovereignty. And we can bring an end to the deaths in the Channel. It has also been suggested, I have to say, that it is improper and contrary to the Ministerial Code to bring in a bill which is inconsistent with international law. This seems to permeate the legal establishment of this country. This is nonsense on stilts, because any member of Parliament, any unimportant member of Parliament, as well as ministers, any backbencher can propose legislation, and private members' bills are enacted frequently, as I have to say, even with my International Development Act of 2014. The acceptance by the noble Lord, the Lord Cameron of Chipping Norton, when he was Prime Minister, despite resistance from the legal establishment at the time that we could refuse prisoner voting, as insisted upon by the Strasbourg Court, is well known and remembered. The former Lord Chancellor and Secretary of State for Justice, the Right Honourable the Lord Clerk of Nottingham, King's Counsel, said that when we refused to accept the, quote, international obligation under the European Court of Human Rights to allow prisoners to vote in elections, he said that, quote, sorry, I mustn't laugh, prisoner voting was a particular political issue. So what about illegal migration? The 2023 House of Lords report makes much of the Ministerial Code and the Civil Service Code, stating, and I quote, that while Parliament is ultimately responsible for the form of any legislation passed, the preparation and introduction of government legislation is an executive action for which ministers collectively are accountable. They then go to reaffirm their disquiet about the constitutional desirability of Parliament legislating in violation of UK international obligations. But they ignore the principles of parliamentary sovereignty, where words in acts of Parliament are used and are clear and unambiguous. And moreover, the Ministerial Code is a convention, not legislation. The words in that code some 10 years ago did, once upon a time, state that the Ministerial Code included the words, quote, an overarching duty on ministers to comply with the law, including international law and treaty obligations. But these were expressly removed from the code in 2015 by the then Prime Minister. The current 2022 Ministerial Code under the present Prime Minister simply refers to the law. This is no accident. The government has declined the Lord's invitation to bring back the words, quote, international law and treaty obligations, and I would say quod erat demonstrandum. The House of Lords Committee also suggested, in reference upon a Court of Appeal case of the Gulf Centre for Human Rights against the Prime Minister in 2018, and a statement 5 years ago by the noble Lord and distinguished Lord, the Lord Folkes KC, that the Ministerial Code still requires compliance with international law obligations. However, I have to say, the Court of Appeal, sadly for them, did not deal with the issue of parliamentary sovereignty, which would be combined with the use of words clear and unambiguous, and in any case did not concern an Act of Parliament. Failure to pass a bill to effectively deal with illegal migration has led to vast public expenditure, billions on services including healthcare, education, social care, housing, infrastructure, planning, just to name a few, not to mention millions and millions on hotel bills. This is why people are so cross, as well as the fact of illegal migration. There is no reason whatever why this bill should not expressly and clearly exclude international law for and within the reasons I have given. It is an affront to Parliament and to the courts to suggest otherwise. I therefore ask that my amendment be voted upon and passed by the House, and I strongly urge the government to note the sheer anger and frustration demonstrated in opinion polls and public concern that we get this bill right and make it work. If not, this anger will continue up to and including the general election. Would it not be wise for the government to reflect on the position, and that it would be better and wiser to come forward with their own amendments and use our majority in line with our manifesto, granted to us by the general election in 2019 and in the national interest, and for the sake of all Conservative members of Parliament whose seats will be so at risk if we do not do so.
Yeah. Dave Diana Johnson.
Thank you, Sir Chair. I'd just like to start by raising my concerns with the government about using a committee of the whole House for this part of the scrutiny of the bill. We had this with the Illegal Migration Act. And what happened was, in that case, there were hundreds of amendments, and the Minister just got to speak at the end for a very short period of time. Now, I think when we're debating and scrutinising bills like this, we need to do so line by line, and we need to debate, and we need to hear the argument from the Minister and the argument from the proposers of amendments. And I just think that this process that we're going through does not allow Parliament to conduct that effective scrutiny that we all want to see when passing laws in this place. So, turning to the bill before us today, when the Home Affairs Select Committee published our report on Channel Crossings 18 months ago, we were very clear about the potential problems posed by the Rwanda scheme. And as I've highlighted on several occasions in this chamber, we said that the small boat crossings is an issue on which no magical single solution is possible, and on which detailed, evidence-driven, properly costed and fully tested policy initiatives are by far most likely to achieve sustainable incremental change. We warned the government that it risked undermining its own ambitions and the UK's international standing if it could not demonstrate that the scheme was compatible with international law and conventions and that aspects of it carried significant reputational risk to the United Kingdom. Now, contained in the amendments today that we're debating are provisions that not only are incompatible with the UK's obligations under international law, but to basic principles of liberty and freedom under common law. The implications of these amendments are therefore profound and affect, I think, every single one of us. And also, despite what the former immigration minister said, I do take in all sincerity what the Rwandan government's view is on the importance of upholding international legal obligations. We can conclude that some of the amendments tabled today would prove fatal to the implementation of the bill, and indeed yesterday the UN Refugee Agency declared that the Rwanda Treaty and this unamended bill are, I quote, not compatible with international refugee law. So I want to speak to amendments 2, 3, 10, 56 and 57 and then focus my comments on amendments 19 to 22. Turning to amendments 2 and 3, excuse me, they would prevent any claim based on risk derived from individual circumstances being considered until that person in question had arrived in Rwanda. This would effectively exclude the very narrow possibility for suspensive claims that the bill currently allows and could result in the person being exposed to the risk on which their claim is based, including claims based on fear of persecution and torture before it's even considered. The European Convention on Human Rights requires independent and rigorous scrutiny of any claim that there exists substantial grounds for fearing a risk of treatment contrary to Article 3. It also requires that the person concerned should have access to a remedy with automatic suspensive effect. So these amendments would therefore be inconsistent with that requirement of the ECHR. Moving on to Amendment 10, that would extend the notwithstanding provision to apply to all of the bill and to the Illegal Migration Act. It would effectively prevent a claimant relying on any pre-existing legal protection to prevent or delay their removal to Rwanda. This amendment would expressly allow for a removal to Rwanda despite that removal otherwise breaching domestic law and despite that removal being in breach of international law, including fundamental human rights, from which, of course, we know no exception or derogations are permitted, such as the prohibition on torture. Needless to say, this amendment is not compatible with the UK's obligations under international law and risks undermining our international standing. Amendments 56 and 57 would provide that courts and tribunals would not be permitted to consider a claim on the grounds that Rwanda is not a safe country, where the claimant has engaged in activity or made serious allegations that have brought into question the safety of Rwanda or colluded or conspired with others who have done the same. Very worryingly, the amendment appears to exclude people who have made serious allegations about the safety of Rwanda from asylum and human rights protection. This would be inconsistent with rights to asylum and humanitarian protection under international law and could also be inconsistent with freedom of expression as guaranteed under Article 10 of the ECHR. I just want to turn to Amendments 19 to 22, amendments that I think have profound implications for all of us. Those amendments would prevent any individual set to be removed to Rwanda arguing that they could not be sent there on the basis of their own circumstances. In the inevitable absence of absolute certainty that no risk to any individual could arise in Rwanda, this would mean that legitimate claims based on a real risk of persecution and human rights violations would not be heard. and that those people whose claims are unheard would be removed to face that persecution and human rights violations in Rwanda on which their claims are based. This is clearly inconsistent with the Refugee Convention, the ECHR, and the other international legal obligations cited by the Supreme Court in its recent judgment. Amendment 22 would also prevent the courts from reviewing not only asylum claims of individuals being sent to Rwanda, but also claims for unlawful detention, for assault in the course of removal, or for discriminatory treatment in the course of the removal process. So I just want to be clear, denying these claims would not only be inconsistent with human rights law, but also with fundamental principles of liberty and freedom under our common law, which has been protected for centuries, including by the writ of habeas corpus. And all members who do not want to see habeas corpus sacrificed today can surely not sacrifice these particular amendments. Finally, I'd just like to add my voice to amendments that I believe to be sensible and logical revisions. I'm just going to carry on because I want to deal with Amendment 1, which requires the Secretary of State to monitor whether Rwanda remains a safe country, and New Clause 6, which places conditions on when the classification of Rwanda as safe can be suspended in accordance with material conditions and or non-compliance with obligations. I'm willing to give way.
Thank you to the Honourable Lady for giving way, and Right Honourable Lady for giving way. She will know that under this government and previous governments of all political colours, many people are deported from this country. People who are here illegally. When that happens, invariably, it is notwithstanding claims they make about their circumstances. Sometimes those are claims about their personal circumstances, sometimes they're claims about the place they're being deported to and from where they come. On the basis of her speech so far, she would deport no one.
I don't know if I am grateful to the Right Honourable Gentleman for that intervention, because that's clearly not what I'm saying. What I'm saying is, and the Home Affairs Select Committee is very clear, is about the rule of law, recognising the international obligations that this country has freely entered into, and doing things properly and legally. And that's what I'm questioning, that some of the proposals that are being put forward today by honourable members opposite are going to the heart of the common law that we have in this country, and our belief in the right to go before a judge, to particularly if one is detained, that you cannot be detained indefinitely. These are important matters before us today. I want to just carry on, because there's a couple of other things I want to get into the record. Just going back to what I was saying about Amendment 1 and New Clause 6, I think while the government has determined in this bill that it's possible to stipulate in law that Rwanda is safe, to the contrary of finding a fact by the Supreme Court, as we know, it doesn't seem to me very sensible for the government to propose that that status should be fixed forevermore, with Rwanda, by extension, the only country on earth in which nothing can ever happen or change. So as such, Amendment 1 and New Clause 6, I think, have merit, which I hope the Minister will consider. Amendments 35 and 37 allow the courts to consider the risk of refoulement in decisions on removals to Rwanda. And given that the Supreme Court ruled unanimously that the Rwanda policy was unlawfully precisely because there was substantial grounds to believe that refoulement could take place, I also think that Amendment 35 and 37 have merit. Now, I understand from media reports that the Minister, when he gets to his feet today, is going to make give some undertakings about increasing the number of lower-level judges, or I should say moving lower-level judges up to the upper tribunal to hear any appeals. And this apparently is to deal with some of the concerns that honourable members on his side of the House have. I just wanted to say to the Minister that the Home Affairs Select Committee is very concerned generally about the lengthy delays in court cases and particularly in one of our recent reports on the investigation and prosecution of sexual offences, and particularly rape, we were very worried about how long it was taking for those cases to be heard. So this initiative that the government have come up with, or perhaps I'm prejudging what the Minister's going to say, but it's being reported in the press, I am very concerned that there's this amount of resource and finance that's going to have to be put into training up this 150 number of judges. It does strike me that the government seem to be using an enormous amount of political time, resource on this particular policy, and I'm looking forward to what the Minister has to say about this issue of increasing the number of judges when we seem to have so many other problems in other parts of the court system that the government haven't so far been able to deal with. And I also, at that point, Sir Roger, I think that concludes my remarks on the amendments that have been tabled today.
5 minutes. Sir Robert Buckland.
Thank you, Sir Roger. It's a pleasure to follow the Honourable Lady, the Chair of the Home Affairs Select Committee. I rise to speak to Amendments 28, 29 and 30 tabled in my name relating, although they relate to Clause 9, they relate to the operation of Clause 2, hence their selection for debate today. And I think it's important that we focus in Clause 2 on what that actually means, what its effect is, what the changed reality is with regard to the position in Rwanda, and indeed the position between the United Kingdom and Rwanda since the not just since the decision of the Supreme Court in November, but the facts upon which the Supreme Court based their decision, which of course relate to the spring, early summer of 2022. There is no doubt that matters have moved on, and moved on quite significantly. Not only do we have a treaty between the United Kingdom and Rwanda that was signed late last year, but we also now have, in the form of a policy document published by the government, and indeed further information, an indication as to the hard and fast changes that the Rwandan government in particular will be making in order to, in effect, answer the questions asked of it by the Supreme Court decision. Because, Sir Roger, the Supreme Court decision really wasn't about the law, it was about the evidence. And when we look at what the Lordships decided, the Supreme Court justices rather decided, it was very much narrowed down to that issue of whether or not refoulement was still likely, bearing in mind the position of Rwanda. Now, the court decided that it was. That's the sole reason why the policy was held to be unlawful. There were other grounds that were tendered in that case. One on retained EU law was a specific ruling of the court that, of course, it didn't apply. The law was very clear that that part of retained EU law had fallen with our departure from the EU. Other aspects of the claim, the appeal, were not ruled upon by the court. So it wasn't a decision based upon compatibility with the ECHR, for example. It wasn't a decision, importantly, that was based upon a challenge that was upheld to the legality of the removal of people to third countries. In my view, it's neither illegal nor immoral to move to seek third country assistance when it comes to this unprecedented challenge. Other European countries are indeed either doing it or wish to do it. And as my right honourable friend, the member for Newark, said in his remarks, he's right to say that other countries are looking to what happens here with regard to the precedent that we might set. In setting precedents, we have to tread carefully, Sir Roger. And that's why the amendments that I've tabled are very much focused towards the factual reality and the need to make sure that Rwanda does indeed carry out its policies. And looking carefully at the policy statement, there are particular tasks that will need to be completed. First of all, new operational training for decision makers in Rwanda. I think the latest figure that we have is that over 100 people have now been trained to implement the deal, and that there need to be clear standard operating procedures with regard to the reception and accommodation arrangements for asylum seekers, safeguarding of their welfare and access to healthcare. And of course there needs to be strengthened procedural oversight of the Migration and Economic Development Partnership that was agreed in 2022 and the asylum processes under it. And that means that bodies have to be set up. The new MEDP Coordination Unit, the MEDP Monitoring Committee of Experts, and the involvement of experts, certainly in the early days of the decision-making to be made by the new body at first instance, which will be set up by the government of Rwanda, and a new appeal body that will consist of panels of 3 judges with subject matter experts, including Rwandan judges and indeed judges from other Commonwealth jurisdictions. All these details are important because they go to answer the question that I think will be in the affirmative, that individuals in this scheme will not be at risk of refoulement and therefore there will not be a breach of the 1951 Convention. That reality has to match the deeming provision. And I know that my right honourable friend, the Minister, will be anxious to make sure that deeming provisions do not either perpetuate or encourage fictions, legal fictions. This is difficult law. But it's not unprecedented. Deeming provisions are, of course, used. They're very often used in tax legislation, and the leading authority is a fairly recent one, Fowler and Her Majesty's Revenue and Customs back in 2020, where it was made very clear by the Supreme Court, I think it was Lord Briggs, who said that deeming provisions creating statutory fictions should be followed as far as required for the purposes for which the deeming provision was created. But what will not be encouraged is the production of unjust, absurd or anomalous results. That's clearly something where the courts do not wish to tread and don't wish to encourage, and neither should we as a government or indeed as a parliament. And that's why making sure that we dovetail the coming into force of these deeming provisions with the reality on the ground in Rwanda means that we're not, in effect, creating a statutory fiction. We're creating a series of facts that is then reinforced by statute. And I think it's that degree of care. And it doesn't have to take ages to do. This can be done in weeks, bearing in mind the quick work that's been done already. This, I think, will go a long way to satisfy the natural concerns that many of us will have about the use of such provisions. We understand why it has to be done. We don't oppose the principle of its use, but we, and I certainly simply just caution that we take care to make sure that we get that coordination right. And now, many of us have been down the road before about ouster, and it can take many different forms. There have been examples, Sir Roger, where ouster proceedings and ouster clauses have clearly not worked. And indeed, it's not the sole province of this government. We saw previous Labour governments try to enact very bold and sweeping ouster clauses, only to find their efforts fell flat, either before the Act became law or indeed as a result of court intervention. I can think of the Asylum Bill of 2004, where Labour tried to be too extensive and expansive. And that's why experience has taught us that where we have very clearly defined reasons, and importantly, where there are limited exceptions, then ouster clauses will work. And we had a recent example of that in the removal of the carte jurisdiction, the Judicial Review Act that my honourable and learned friend, my right honourable and learned friend, finished the job on, which I started the job on in the consultation on the Judicial Review provisions that my noble friend Lord Folkes and others embarked upon at my direction. And that worked. It's been tested not just in the High Court but now in the Court of Appeal in the Oceana case, and it's held to be sound and watertight. Why? Because there was a very clear rationale behind it, and secondly, there were limited exceptions. And herein lies the danger, I'm afraid, that is posed by the otherwise well-intentioned amendment by my honourable and right honourable friends. If you don't have those limited exceptions, you're setting this up to fail, Sir Roger. And that's what I think history has taught us. I'm absolutely a proponent and a strong believer that it is from this place that the core of our constitution comes. It is from Parliament that our constitutional authority is derived, and that to contradict the honourable gentleman member for Aberavon, who in many respects I think characterised and couched his remarks well, we're not a separation of powers constitution. We're a checks and balances constitution where each part of the body politic respects each other. And here I agree with him. I think restraint is an important principle. And I'll give, well, of course, to my right honourable and good friend.
My right honourable friend is making a very profound and important point about the nature of the separation of powers, and there is a lot of misunderstanding about this abroad. The separation of powers is not about equal bodies. It's not about each of those bodies performing the same role. It is entirely a matter, as he describes, of a balance between those bodies, and this House is the body that makes laws. Judge-made law is something he and I have debated and discussed and agreed on many times, and it is invidious because this House, as I said earlier, is supreme when it comes to making or changing law.
I entirely agree with my honourable friend, and he and I are both romantic Tories of an old school, which might surprise many members in that we do share that common fount of Toryism that is important to us both. And within that, we utterly respect the independence of the judiciary. It is a separate part of our constitution, and the idea that, as sadly in the Post Office case we've had to, that we trespass upon their domain is something we do extremely reluctantly, and I hope in a very rare and unique way in that very tragic and scandalous example. But that, as he says, does not mean that we are a carbon copy of the United States. In fact, the United States Constitution is itself based upon a misunderstanding of the British Constitution. And it is not right to say that separation of powers is the underlying principle. That fiction, I'm afraid, led us into error when we, to my mind, regrettably took the House of Lords Judicial Committee out of this place and pretended that somehow it was entirely separate from Parliament. The point about the House of Lords Judicial Committee, if I may digress for a nanosecond, Sir Roger, is that it was a body of Parliament making law. And that, I thought, was an elegant solution, an elegant response to our unwritten constitution. The same goes for the office I used to hold. What a mess the previous Labour government made of reform to the office of Lord Chancellor, which I thought was the embodiment of the checks and balances that we have in our constitution. It's a bit of cod philosophy that is overused and is not actually part of our system. But I will go on to qualify that in an important way before I give way to my honourable friend, the member for Gloucester.
But I just want to bring him back, in a sense, to the amendments today. And does he agree with me that between the absolute conviction of the Honourable Member for Aberavon and the opposition that this cannot ever work, and the absolute conviction of the Right Honourable Member for Newark that he can only work with his amendments, there is actually a landing space where we can deliver something that will make a difference, that will act as a deterrent, without getting rid of all the individual rights that we have in our domestic and international law, and that is what we should be aiming to achieve.
Well, Sir Robert Button, I think my honourable friend puts the point very well. There is, I think, a landing space for this policy. I disagree with Her Majesty's loyal opposition and their leader when he said that he wouldn't support the Rwanda policy even if it worked, which I think, frankly, is an extreme position. It's not one that chimes at all with what the British people want to see, because they want to see solutions to these problems. And it is this party and this government that is coming up with solutions. They might be novel, they might be untested, but at least we are working on it. Yes, of course I'll give way my right.
Well, my right is very generous. With all his experience as former Justice Secretary, is it his view that the Ministry of Justice will be able to recruit hundreds of tribunal judges, from where, I don't know, recruit them and use them to process and decide the claims that will surely come from each and every illegal migrant that comes across the channel in sufficient speed so that we do not fill up our detained estate capacity and have to bail those individuals so they abscond, even in the peak season of August and September. His professional opinion would be much appreciated.
Well, I'll give him, perhaps if not a professional opinion, the opinion of born about experience, in that anything is possible, Sir Roger, but it is quite a task. And I'm sure that my right honourable friend, the Lord Chancellor, will be talking to the Senior President of Tribunals, Sir Keith Lindblom, about this very issue to make sure that not just full-time tribunal chairs, but part-time tribunal chairs as well, will be available in order to deal with this large number of cases. And I'll say this, if we can do it in immigration, can't we do it in crime as well, please? I think it's a high and timely reminder of the fact that our justice system is pretty important, and that despite my best efforts to increase funding, which we did do, more needs to be done in order to ensure that those backlogs are dealt with. And I know that, and I declare my interest, I know that my colleagues at the bar would tell me off if I didn't say anything else. But, you know, to answer my honourable friend's point, it is going to be a challenge, and it is going to require probably some changes to practice directions and a particular way in dealing with cases that will have to be much quicker than the status quo. And I'll give way to my neighbour, my honourable friend.
My honourable friend is being very generous, and I appreciate the speech he's making. Just on that last point, does he also acknowledge that the government's intention of recruiting this large number of extra judges implies that they themselves expect to have a large number of claims being made on behalf of the migrants who come, rather than being them swiftly detained and removed, as we all wish them to be?
I think I'm inclined to be kind to my right honourable friend, because I think that it's probably not an either or, it's an and, in that he and the government will want to achieve not only a further spur to dealing with current cases in the system, but will also want to deal with any particular influx that we might get because of novel points that will need to be tested. I'm satisfied, I have to say, having looked at the terms of the clauses currently drafted, that I think it is narrow, and I think if not quite the eye of a needle, it certainly will be a pretty restrictive process. I remember, Sir Roger, having deep frustration at the time of COVID in not seeing backlogs in the Immigration Tribunal come down, despite the fact that people weren't coming into the country. And therefore I would gently, and I will give way on that point.
Just add, since he left office, he may not be aware that the current waiting time for an appeal before an immigration tribunal is 48 weeks. And given the thousands of cases that we've successfully cleared in the backlog, many of whom, thankfully, have been rejected cases, that backlog is probably likely to double in the coming weeks. So currently, immigration tribunals will be taking between 1 and 2 years to hear a case.
And he's right, because he's building on the frustration that I had, in that I'm afraid my colleagues, and it's not the criticism of ministers, but it was the way in which the Home Office was working just didn't seem to allow that expedition that was needed. Now, I know that he and others have done a lot of work to improve that, scaled up the number of officials dealing with cases, and really put a sense of urgency, a wartime, if you like, an emergency approach to this, which I think is entirely right. But I can tell you, back in 2020, I was deeply frustrated not to see a decrease in the backlogs, bearing in mind in other areas we were actually making a difference and taking at least some benefit from that awful COVID crisis. So, the challenge facing my right honourable learned friend on the front bench is a significant one, and we shouldn't pretend otherwise. I will give way very briefly, yes.
Whereas the practice of government, certainly over the last 14 years, has been where there are bottlenecks, and we saw them during the pandemic in DVLA, we saw them in the Passport Office, we saw them in the Home Office, The answer to those questions was for ministers to energise that particular department, recruit more people, allocate more resources, get the backlogs down. If it can be done in all those places, there is no reason, surely, why it cannot be done in this hypothetical instance of lots of extraneous claims by people in order to avoid extradition to Rwanda, given the very narrow scope that is allowed in this bill.
Where there is a will, there is a way, and I entirely agree with my honourable friend. In the moments that I do not want to detain the House unduly lengthily today, perhaps some would say uncharacteristically, but I really don't. I want to, well, you see, self-deprecation takes you so far in this place, Sir Roger. But I yield to my honourable friend to Stone in that department. I want to conclude by saying this, that Privacy International, which was a Supreme Court case of about 3 or 4 years ago, I think is a warning about where governments, with good intention, try and overreach and wholly exclude a particular judicial review approach will often fail. And in that case, we saw, I think, an inevitable consequence of a line of thinking that has gone back in our law for about 50 or so years since the Anisminic case. And we have to be alive to that reality. We shouldn't be putting the courts in a position where we end up with what was a highly contested case with dissenting judgments, but which in the end, I think, gives us a very important guide as to how carefully we need to approach these matters. I'm not going to pretend, Sir Roger, that I can ever love notwithstanding clauses. I don't like them because I think they create all sorts of internal conflicts, not necessarily conflicts at international law. I'm less interested in that. I'm more interested in conflict in our own domestic law. And I think anything that this House does that is ambiguous, that is contradictory, self-contradictory, that is unclear, only serves to draw the courts further in to the realm of, frankly, of politics, which I know none of them ever want to go. We do not have a constitutional court in this country, and I hope we never ever see one. Because of our unwritten constitution, we are able as a parliament to legislate as we wish. But this is the qualification. I said at second reading that the principle of comity, that mutual respect that needs to exist between the arms of the Constitution, is one that means that we do need restraint, that we do need to take care when we legislate, and that however grave the situation might be, and our previous generations faced wartime challenges, we must remember that in legislating in this place, we do not protect ourselves out of the very freedoms that we cherish. Because at some point, it won't be a Conservative government sitting on these Treasury benches, it will be a government of another hue. And I hope, Mr Sir Roger, having been in my party for nearly 40 years, I'm much older than I look, that we don't see that day. But a day will come. And we, as an opposition, will be worried about an overweening socialist government that will try and impose its will through the will of Parliament and will not show the restraint that we expect a democratically elected government to show. And that's why the challenges that we face, and I'll give way very big, but I just want to finish this point. The challenges that we faced during Brexit were exceptional. And I do not think that, despite the maelstrom that we all went through and some of the things we had to do in order to get that done, I don't think we should be seeking to normalise them now. And I'll give way to my right honourable friend.
John is once again right that this place should not act in an arbitrary way. And I mentioned Dicey earlier, and be familiar with Dicey's view on that subject. But in the end, our legitimacy is derived from the people, and we are answerable to the people. On this issue, above all others, the people expect us to stand by our pledge and to stop the votes.
Yeah, they do.
So Robert, and I agree with him that we're not just another public agency. This is Parliament. And this place has a particular status and position and responsibility and privilege. That word privilege that he and I know and cherish so much in its true sense. that means that we are absolutely at the core of our democracy and our constitution. But it's also our responsibility to make sure that the legislation we pass works. And I know that he and my friends who are supporting the amendment want this law to work, and I absolutely accept that. But I say in all candour and in all frankness to them, I genuinely think that the amendments that they bring forward will make it less likely. And I don't say that with any pleasure, I say that with a heavy heart, because I think that history has taught us that where, despite good intention, we end up being too expansive and where we overreach, then the check and the balance that exists in our constitution will apply. And all we'll do is end up having the sort of, not to me arcane, but to many people arcane, arguments about the constitution that are important, but which don't solve the problem and don't deal with the issue that is facing us as a people. And that's why today I urge the government to make sure that the intention in the treaty becomes a reality, that Rwanda does do what it says it's going to do so that we can avoid refoulement, and that we really focus on the practicalities and avoid more unnecessary legal clash where I'll quote Matthew Arnold, the ignorant armies clashing by night is something that we as Conservatives should seek to avoid at all costs.
Olivia Blake.
And I'd like to point to the House to my declaration of registered members' interests for the help I received from the Refugee, Migration and Asylum Policy Project and as co-chair of the all-party parliamentary group on migration. I agree with much of what the Right Honourable Member for Kingston-upon-Hull mentioned about the process of this bill and the way in which we are debating this bill today. This is the third immigration bill in less than 2 years. Throughout that time, government ministers and backbenchers have engaged in progressively more inflammatory rhetoric about refugees without addressing any of the real problems in our asylum and migration system. And let me be clear about what those problems are. The real problem has been brought into stark view just this weekend. 5 people died crossing the Channel, and hundreds have been killed making that dangerous crossing. If those desperate people survive that journey, they are forced to wait years for a decision on their claims. They are housed in uninhabitable conditions, they are unable to work and give back to our society, so they are in danger of destitution. And if they are destitute, they are forced to rely on only a small sum of support, barely covering the cost of basic essentials. The complete lack of functional, safe routes available to people. Those are the real human problems and the real cost of human life.
Well, friend, give way.
Yeah, I'll give way.
Many of the amendments today relate to whether Rwanda is or isn't a safe country. Would we not be in a different place if we had a much broader range of safe and legal routes, and therefore we wouldn't have small boats crossing the Channel and no need to discuss whether Rwanda was a safe or not country, which is not helpful to them or to us?
No, I absolutely agree with the member for Leeds North West. I think that that's a really important point and one that we're struggling to get much sense out of government on. You know, I've asked questions repeatedly about areas in the world which have declared genocide, if there are safe legal routes available to those individuals trying to flee that. Unfortunately, the answer is the safe and legal routes we have that exist are all that we're going to offer. And I don't think that is good enough. I think we need to have another conversation and look at safe and legal routes. But to go back to the point I was making, you know, those are the real human problems and the real cost to human life and well-being that the government's hostile environment policy brings. The Safety of Rwanda Bill in front of us today is another example of ministers doubling down on that approach. The amendments from the government backbenches, I believe they are amendments 10, 19, 20, 21, 22, 56 and 57, take it even further. As yes, I'll give way.
Safe and legal routes. As she knows, I agree with her that we do need to extend safe and legal routes, which is why we have clause 61, the amendment I put down, which I hope the government will honour. But does she not also acknowledge that even if you have safe and legal routes by which legitimate refugees fleeing from genuine violence and oppression can use, those who don't have those criteria the bogus asylum seekers will still use people smugglers, and that's why we need to absolutely be able to deter and clamp down on them so they don't set foot on our shores.
We need to have the safe and legal routes in first, and that's the problem that we're facing, because we've got a situation where the rates in which people are accepted as having a reasonable claim and are given a form of leave to remain in the UK is very, very high, 67% in some cases in recent years of people getting their applications accepted. So I don't believe that we are in a situation where there is a large number of people coming here illegally without good claim. I think actually the counter is true, given the evidence that we have in front of us, from the evidence from our own system approving people through our systems that we have at the moment. I'll happy to wait.
Interesting point. So how can she explain, for example, where France receives a higher number of asylum applications than we do, but rejects twice as many as we do? What are we doing differently?
Exactly.
Well, I hope that our system would have the trust of its politicians, and I'm very confident in the systems that we have, that they are robust enough to make sure that we're making the right decisions where possible. Although I do still agree that there should be an appeals process within that system, because I can't say that the system always gets it right, and certainly in the casework that I've seen, it doesn't always get it right either. So I think it's more complicated than saying this action will reduce this or this action will increase this. I think it's a very, very complicated system where the most obvious thing to say about it is, the second and third highest in the last few years and months of people arriving here in small boats has been people from Afghanistan. We are seeing people fleeing Syria, we're seeing people fleeing all sorts of different conflicts and difficult situations at the moment, and that doesn't actually take away from the fact that it's not necessarily about the nation you come from. It's also about the individual circumstances of you as an individual. And I've spoken a lot about the rights of LGBT people seeking asylum, disabled people seeking asylum, and how we need to make sure that any system we do have does maintain that individual view of an individual going through our systems. And that is lessons that should be learnt from the Windrush Review as well. And moving on, but at its core, it is a policy designed, the hostile environment, is a policy designed to make life as uncomfortable as possible for everyone that comes here and prevent anyone from accessing support that international law says is rightfully theirs. And now the government is proposing to outsource what little responsibility it has taken, offloading obligations and offshoring refugees against their will. No wonder then that it is recklessly declaring Rwanda is safe despite the known risks. Since the government signed their deportation deal, as the Shadow Minister pointed out, 6 people from Rwanda have been granted asylum here in the UK. Torture persists there, along with continued risks of refoulement to third countries, which is the reason I support Amendments 35 and 37. Human Rights Watch reports on Rwanda as part of their World Report series published in 2021, 2022 and 2023 all include examples of torture in Rwanda. And the UN Human Rights Council's periodic review of Rwanda in January 2021, it was the UK government that criticised Rwanda for extrajudicial killings, deaths in custody, enforced disappearances and torture. The country has a continued history of breaching obligations under the Refugee Convention. Between 2020 and 2022, UNHCR found that Afghan, Syrian and Yemeni asylum seekers had a 100% rejection rate in Rwanda. Statistics that I'm sure people would find shocking given our granting rate. Discrimination and abuse faced by LGBTQ+ people in Rwanda are common, same-sex is prohibited, and LGBTQ+ people are not protected from discrimination by any specific legislation there. All this makes a mockery of Clause 2 of the bill, and Mr Chair, ministers can continue to use ad hoc bills such as this to paper over the cracks in their asylum policy, but the truth is the foundations of their approach are completely rotten. Rather than chasing headlines, it's time they thought again and built an asylum system that puts respect for international law and basic human dignity first.
Yeah.
Yes. Sir Edwardley.
Thank you, Sir Roger. Immigration, I think, is quite possibly the most important issue facing this government, or indeed any government in Europe. It is the issue of our age, and mass immigration, whether legal or illegal, is undermining trust. This debate has got to be held against the overwhelming numbers coming into our country. So, Roger, when you and I entered Parliament on the same day in 1983, during that year, net legal migration was only about 17,000. It's now 600,000. So this debate about small boats is against that backdrop of this huge influx into our society, which is changing our society, in which the British people have not been consulted, and of course is undermining the own work ethic of our own people. Too many people are languishing on benefits. Perhaps some of our public services are not paying adequate salaries. We are bringing in more and more people into this country, whereas we should be encouraging and training our own people to work. So this whole small boats crisis, in a sense, is made much more toxic by that debate. So when people say, well, 40,000 people isn't a great deal a year compared to what the sort of numbers coming across the Mediterranean, one's got to see it in terms of that overall debate. And unless the government can sort this out and actually stop the boats, which was the commitment made by the Prime Minister, I think it will be extraordinarily politically damaging to the Conservative government, but also damaging to the public's perception and belief in democracy, that when the Prime Minister says he wants to stop the boats, he should stop the boats. And that's why I'm supporting the amendments tonight and tomorrow put forward, most ably, I have to say, by my right honourable friend for Newark and for Stone. And I'm also put forward my own amendment, numbers 56 and 57. And I'll explain what they are about at the moment. Against this whole backdrop, I think in a sense we have an extraordinary and absurd situation. People are arriving in Calais. They have travelled through an entirely safe country. There is no threat to their human rights. They may find it difficult speaking or may not want to learn to speak French. They may not be able to find a job, but they are an entirely safe country. And then they're putting their life at risk. And even this week there has been an appalling tragedy, and we are encouraging the most horrible criminal gangs to get involved in this trade. And then they arrive here and they claim asylum. Unbelievably, we're putting them up comfortably in hotels, which other European countries don't do. And even more extraordinarily, and I won't labour this point because I've made it many times before, such is the crisis in our hotels that the government is now spending tens of millions of pounds on trying to convert former military bases, such as RAF Scampton in my constituency. And by the way, we've been arguing about RAF Scampton for 9 months now. Not a single migrant has arrived there. And there's still these court cases going on. So put yourself in the place of the migrant. The draw factor of this country is extraordinarily high. First of all, we speak English. Secondly, unlike in France or Germany, you will be put in a comfortable hotel. Thirdly, you're given benefit. Fourthly, you will stay in your hotel, and there's probably a 95% chance that you will be given asylum at the end of the process. If you are coming from a hellhole like Syria or Iraq or Afghanistan, why would you not want to take that risk? I mean, we must be mugs, frankly, and the rest of Europe must be laughing at us. Well, I give way to the Honourable Gentleman.
I mean, this is the question that the Honourable Member for the Rwanda was making. If
it's so attractive to come to the United Kingdom and nothing else has been a deterrent. If crossing the channel and the risk to your life that involves is not a deterrent, why should the prospect of being sent to Rwanda be a deterrent, particularly if Rwanda is a safe and secure country where they can have a comfortable life? Why should the prospect of being sent there be a deterrent?
What is the solution? You know, I think members opposite, when they're making these arguments, have to say, what on earth will they do? I mean, by the way, I do agree one thing with the opposition, that it seems clear to me that with modern surveillance technology, with drones and all the rest of it, it's a bit of a mystery to me why we are not managing to stop more people. And with modern police efforts, it's a bit of a mystery to me why we can't interdict more of these criminal gangs. But it is so easy to get involved in this trade. You close down one criminal gang, as the opposition wants to put more resources in to do, and another one will spring up. So I think it is incumbent on the opposition, given that we are in such an attractive country, to explain how on earth they're going to stop this trade. By the way, I do question now whether we can proceed with this policy of keeping people in hotels, paying the benefit, giving 95% of them, approving 95% of their applications when they have come through a safe country. So the problem I have with the government is not their Rwandan policy, because I accept that if you look at the example of Australia or elsewhere, the only policy that seems to have any chance of discouraging this mass movement of people is an offshoring policy. My argument with them is that if we pass this bill, and we keep passing bills, such is the nature of our legal system, that people will make spurious claims based on their political opinions, which will make it impossible for them to be put on a flight to Rwanda. That's the nature of my amendment, and that's why I talk about spurious claims. Now, let's give one example. I am an illegal migrant. I've paid all this money to get through France. I'm now going to put my life at risk. I've put a lot of my personal resources into this project. I am absolutely determined that when I arrive in Dover, there's going to be no chance of me being sent to Rwanda or anywhere else. It's so simple. You can manufacture some spurious opposition to the Rwandan regime. You can do a tweet. Even I can do a tweet. You can do a tweet in... You can do a tweet in... You can do a tweet in 5 minutes saying that the President Rwanda is a dictator, that he should be overthrown, and you've done it. It's now gone worldwide. Or you can, once you get into this country, you can simply do as has happened outside the Saudi Arabian embassy. You simply protest outside the Rwandan embassy about the president. You can so easily concoct a spurious reason why, whilst Rwanda generally may be a safe country, for you personally, because what of you have done, demonstrated, tweeted, you cannot be sent there. And this will clog up our whole judicial process. And we've already heard from my right honourable friend for Newark that in the month of August you may be having hundreds of crossings every week. Every single claimant will take his case to the tribunal. It will have to be heard. There will have to be appeals. I cannot see how any of these people are actually going to be put on these flights by next October, when there may be a general election. Or then there may be a very small number, but given the nature of the judicial process and the right to appeal and the ease with which you can concoct a history of opposition to the Rwandan regime, I don't think anybody is actually going to be put on a flight. Or you can concoct so easily a history of mental illness. It's so subjective. It's easy enough to find a doctor to sign a medical certificate saying that you have a history of mental illness. It's easy to concoct a personal history. For instance, if you come from Iran, that you allege that you are gay, for instance. Again, no tribunal will export you to Iran if you say that you are gay. And so if you come from Iraq, You can say that you are an activist Christian, whether you're not or not. I cannot see how anybody who has a right to go through the judicial process, given the ease that you can create a history, a personal history, which will make your own personal circumstances impossible in Rwanda, I can't believe that any court or any tribunal will export somebody to Rwanda. Yes.
He's talking quite ridiculously about people concocting stories, and I feel that he is perhaps concocting one himself. Can he tell me when he last spoke to an asylum seeker?
They may not concoct it. It may be entirely true. We don't know. But what we do know is that every single person who arrives in Dover will say, and we all know this is true, every single asylum seeker will say that they cannot be sent off to Rwanda because of their own personal history, and every single one of us would do the same thing. And then we had, of course, the farce last year, and we'll be discussing this in more detail, of the judgment issued by the Council of Europe. And I'm a member of the Council of Europe. I've been there 14 years. We now know that this ex parte judgment, this Rule 39, was perhaps not delivered according to international law, and apparently now in discussions with the Court of Human Rights, we have sought assurances that it's going to be tidied up. But even if our own courts allow somebody to proceed through them, their case to be heard, even if we manage to appoint sufficient number of judges, even if they don't create a history, even if they, through our own courts, are allowed to be put on a flight, there is this right of appeal to the Court of Human Rights, and we have no certainty that these cases won't be heard, they won't be delayed. I mean, I do accept that this is the toughest bill that we have ever had. It's a good bill in its own right. I do accept that if we had produced it 2 years ago, it may be by now we would be getting people on Rwanda, but time is now running out. Until the next general election, we perhaps have 9 months. I cannot, in all honesty, accept that if we don't amend this bill, if we do not amend this bill, we could end up in the worst possible situation where we say, we as a government are committed to stopping the boats, we have passed the necessary legislation, and then we have egg all over our face because nobody is actually put on these flights. We will look extremely stupid. The only solution Yeah, I will. I think the only solution, in my view, is that when you arrive here, you are, as my right honourable friend from New York said, you are detained. With a matter of days, you are offshored, and the only justification you can have for not being put on the flight is a proper medical condition. That is the only way which will get people on these flights. Yes, I give way to my honourable friend.
I'm grateful to him. Can I just posit a slightly different approach, which is, as he has said, that all of us on these benches want to do something about the problem. There are people on the other side of the House who are quite happy to subcontract our immigration decision-making to the evil people smugglers operating small boats across the Channel. But we are united on trying to do something. The only issue on which we differ is the extent to which we wish to override all domestic and international law on individual human rights. And he, as a man who has stood up for some of his constituents in their most difficult times, will understand that to do so would be a massive step that most of us on these benches are not prepared to take. So therefore the question is he prepared to see this through in the face of opposition from those who at times risk looking as if they're keener on putting sub-postmasters in jail than illegal immigrants, and make sure that we do have an option and a deterrence which will almost certainly work? Or is he prepared to sacrifice that huge step forward on the altar of an amendment to try and rule out all possibility of any individual human rights complaint being upheld?
In a way, to be fair to my honourable friend, I don't like what I'm suggesting, but we are faced with a national crisis, and we have to look at our own experience of what has worked and what has not worked. And we all know that overwhelmingly, the people who are crossing are economic migrants. They're all perfectly nice people. I make no complaint about them personally. They're just trying to get a better life. We all know that they will do anything, and we all know this is the truth, they will do anything to avoid being put on one of these flights. And although I agree with my honourable friend, we wouldn't normally want to circumvent normal rights, in this case, we know that is what is going to happen. So we're arguing almost on the sort of pin of the needle about legal uncertainties, where we know from practical experience that everybody will appeal, everybody will be able to create a credible case based on political involvement, their personal political involvement, or on their mental health or any other reason, and nobody, or only a derisory number, will be put on this flight. So I'm afraid the government really should grasp this nettle. I fear they won't, and they should accept these amendments. And if they don't, I think we're going to be, in terms of public opinion, in a very dangerous place.
It's always an interesting one to follow the Honourable Member for Gainsborough, but I am pleased to have the opportunity to speak today on the amendments on this bill tabled by my Right Honourable friend, the Shadow Home Secretary. As we consider the amendments and new clauses before us, I want to start by acknowledging, as my honourable friend and member for Sheffield Hallam has done, how awful it is that more lives have been lost this weekend in the cold waters of the Channel. More families are grieving whilst dangerous criminal smuggler gangs are making huge profits from these perilous boat crossings whenever the weather calms. They must be stopped before any more lives are lost, and that requires action, but it must be the right action. The Tories are in total chaos about this failing scheme, which is costing the British taxpayer £400 million, with more money promised, even though not a single asylum seeker has been sent to Rwanda. Every new detail of their plan is more farcical than the last. And yes, we all know that there have been far more Home Secretaries sent there than asylum seekers so far. Even if they do get it off the ground, it will cover less than 1% of people arriving in this country or people in asylum hotels, making it astronomically expensive. And that's why I support new clause 6 in the Shadow Home Secretary's name. This new clause places the Monitoring Committee for the Rwanda Treaty on a statutory basis and places conditions on when the classification of Rwanda as safe can be suspended in accordance with the material conditions and/or non-compliance with obligations under the Rwanda Treaty. This new clause is absolutely the right thing to do, and I would urge ministers to look at it very seriously indeed. In April 2022, the British government and Rwanda signed a memorandum of understanding to provide a migration and economic development partnership. It's a 5-year agreement, 2022 to 27, and under this deal, the UK pays Rwanda large sums of money as part of its Economic Development Fund, which has no impact on the asylum system. In return, Rwanda has agreed to take responsibility for some of the people who arrive in the UK on small boats. They will be removed to Rwanda, where their asylum claims will be processed. But the UK will have to pay extra costs for asylum processing, decisions and support. In June 2022, we know the European Court of Human Rights issued an injunction that halted the first attempted removals until legal proceedings had concluded in the UK courts. The High Court backed the policy. The Court of Appeal declared it to be unlawful. In November 2023, the UK Supreme Court upheld the Court of Appeal judgment, and it ruled unanimously that Rwanda policy was unlawful because there were substantial grounds to believe people transferred there could be sent to countries where they would face persecution or inhumane treatment, a practice known as refoulement, if Rwanda rejected their asylum claims. This is why new clause 6 is so important and would be a welcome addition, and a much needed one at that, to the bill. Through our frontbench amendments, Labour has tried to guide ministers in the right direction and importantly stand up for both our values and our commitment to the strongest border security. That is why the Labour's plan is so important. It has my support. Labour's plan will strengthen our border security, smash the criminal gang networks and their supply chains with new powers and a new cross-border police unit, so we stop the boats reaching the French coast in the first place. We will clear the backlog with new fast-track systems, end hotel use, saving the taxpayer over £2 billion, and improve enforcement with a new returns and enforcement unit to reverse the collapse in returns for those who have no right to be here. On these benches, we believe in strong border security and a properly controlled and managed asylum system. So the UK does our bit to help those fleeing persecution and conflict, but returns those who have no right to be here. And that is why new Clause 6 is so worthy of support from across the House. It means we stay true to who we are, good neighbours, committed to doing what is right and for standing up for those most in need. And that's the kind of global Britain that I am committed to. Getting this wrong wouldn't just be a cost to our reputation. This whole scheme has a massive financial implication too. The full cost of the Rwanda scheme have not been disclosed, and what details that are available have emerged in a haphazard way through Home Office documents, official letters, comments in Parliament and a leak. Sir Matthew Rycroft has said that he is not at liberty to disclose the full cost as they are contained in a confidential memorandum of understanding between the two governments, saying it was commercially sensitive information. He said the Home Office annual report and account sets out details of the cost for the relevant financial year. The report is usually published in July. But the government has set out the cost for future years for the UK's security collaboration with France. In addition to payments of at least £232 million between 2014 and 2023 to combat illegal migration, the government has agreed to pay the French sums of £124 million this year, £168 million next year, and £184 million the year after. These costs were set out before the payments were made in a public document. And that's why our frontbench amendments are so important. This bill is way off the mark, as are the motivations behind it. Anything we can do to improve it should be a priority. Sir Roger, turning specifically to Amendments 35 and 37, which also have my full support, Amendment 37 ensures that decision makers are still able to consider the risk of refoulement when making individual decisions on removals to Rwanda. And Amendment 35 would permit courts and tribunals to deal with systemic risk of refoulement from Rwanda. These are two very important amendments, and I would urge the Minister, like I did with New Clause 6, to think very carefully about the merits of them. In 2019, the Conservatives promised to end boat crossings in 6 months. Since then, the number has rocketed. In January 2023, the Prime Minister pledged again to stop the boats, but since then, almost 30,000 people have crossed the Channel, the second highest number ever. It means that in 3 years, over 100,000 people have made this treacherous journey. The new Home Secretary said that hotel use is going down, but the number of people in asylum hotels hit a record high of 56,000 in September 2023. That's over 10,000 more than when the Prime Minister pledged to end hotel use the previous year. The British taxpayer is now spending an astronomical £8 million a day on hotels, thanks to the Conservative chaos. That's £3 billion a year. Almost 350 hotels are still being used and criminal gangs are being let off. Under the Tories, the annual profits of criminal smuggler gangs have soared from 1 million 4 years ago to over 100 million today, and convictions for people smugglers have dropped by a shocking 36% since 2010. So, Roger, this whole situation is a mess. It's a mess for the government, and we are all so bored of the pathetic scenes of whips and ministers scuttling around to peel off the rebels. It's a mess for our borders, and it's a complete mess when it comes to our international leadership. The amendments I've spoken in favour of today would help make a bad bill a little better. And I urge ministers to do the right thing and listen. Labour stands ready to help Tory ministers finally get a grip, and the sooner the better.
Thank you for calling me to speak. It is important to raise in reference to my amendments 1, 2 and 3 to this bill, and some others that I'll cover during the course of my remarks. I'm not a lawyer, I'm not an immigration specialist, but I have sought advice, I've done my research, and above all, I've spoken to the people of my constituency. This is the first time I've been sufficiently animated to speak in a debate on this issue. Contrary to what we hear regularly from honourable and right honourable members, when I walk the streets of Delyn and speak to my constituents, almost none of them raise the issue of illegal migration as being in among the things that they are most concerned about. I appreciate that rural North Wales is a different place to many constituencies, but it's worth noting for the record that it isn't the priority of everyone in the country. who would rather the government was spending more time improving public services, keeping our streets safer, and returning us to a period of more economic stability and, dare I say it, aiming for prosperity. But here we are, in another effort to solve the intractable problem of small boat crossings with this bill. Some elements don't necessarily sit well with me, but some of the amendments sadly sit even worse. And some of the rhetoric that we hear on this subject is quite alarming. I've tried in my small number of amendments to apply a little common sense and compromise, neither of which appear to be in abundant supply when it comes to discussing this particular issue. I listened carefully to the Right Honourable Member for Newark, who was sadly no longer in his place earlier, who spoke passionately on this issue and answered my question and others put to him in interventions very well. But I can't help but retain a feeling of fundamental unfairness in some of his amendments, and I'll expand upon that later on. But I have my own amendments, so turning firstly to Amendment number 1, which seeks to compel the Home Secretary to confirm on an ongoing basis that Rwanda remains a safe country. No interest, Mr Evans, in restarting the debate as to whether it's safe now or not for the purposes of this legislation. We are assuming that it is. What I'm trying to address in this amendment is the issue of political and social instability that exists in many parts of Africa, and that regime change is more common in that part of the world than in any other. It'll be 30 years this year since the horrific Rwandan genocide in 1994, and a lot of things have happened in those years, largely down to stability and the steps taken by President Kagame. It's probably worth noting that in the time since 1994, Rwanda's had 2 presidents, whereas the UK has had 8 prime ministers of varying levels of honesty and competence. So it would seem an unusual thing for me to table this amendment with the concern of regime change. But it's a real concern nonetheless. In 2021, coup d'etat ousted 4 heads of state in sub-Saharan Africa. Elected leaders in other African nations were accused of enacting a more authoritarian approach, presumably to stave off a similar rise of forces against them. Between 2017 and 2019, President Bouteflika of Africa, President al-Bashir of Sudan, and President Mugabe of Zimbabwe were ousted after a combined 90 years in power. In a paper released 2 years ago, almost to the day, experts from the London School of Economics and Political Science showed that, and I'll quote them, their removal, rather than a direct consequence of mass protests and economic downturns, was the culmination of ripened factionalism, which had blossomed after the leaders' attempts to centralise power. It simply goes to illustrate the potential volatility of politics in the region and the rationale behind my amendment. It isn't a particularly onerous requirement that the Home Secretary must lay before the House a report every 12 months, confirming that Rwanda remains safe. As a responsible partner to various international agreements and conventions, this would seem like the least we should do in that regard. Moving on to Amendments 2 and 3, which I'll take together as they're related, as well as comments relating to other amendments on the same issue. For me, Mr Evans, again, as a layperson and not legally trained in any way, but hopefully with a decent dose of common sense, it seems unthinkable that individuals against whom any kind of judgment is made would not be allowed the right to appeal against that judgment. This type of thinking puts our legal process back 100 years and is frankly beneath us and beneath what this Parliament should stand for. We have, in this country, a robust and well-established legal system from magistrates to county court, Crown Court, High Court, Court of Appeal and finally the Supreme Court, with various tribunals and other such devices for specific purposes. We allow, as a matter of law and simple fairness, people to question and appeal. Shoplifters can appeal. Car thieves can appeal. Abusers can appeal. Perpetrators of domestic violence can appeal. Rapists can appeal. Murderers can appeal. I've listened carefully to the arguments of some of my colleagues, both personally and what's been said in this House and in various media outlets. And I'm afraid I feel compelled to conclude that the trend towards dog whistle politics and putting the label of enemy onto people where no such label needs to apply seems to have got the better of some people. And I'd like to point out to colleagues that although it's often the noisiest voices that call for these people simply to be rounded up and shipped out, The noisiest voices are almost certainly not the voices of the majority of the people of the United Kingdom, which is and always has been a welcoming and kind country to those in need. We can point to all manner of schemes, Mr Evans, to show that this has been the case. Even recently, between 2015 and June of last year, more than 179,000 people arrived in the UK from Ukraine. Over that same period, more than 123,000 people have come to the UK on the basis of being granted British national overseas status. More than 50,000 people have come as part of the Afghan and Syrian resettlement programmes. We are a kind and supportive country to those in need. But have we become what many consider to be a soft touch? Perhaps in some ways we have. I would look at this issue of movement of people in two distinct ways. You're either moving away from something or you're moving towards something. And what I mean by that is, of course, some people are, as we all know, in a horrific situation. Whatever people think of the government in the UK, it doesn't carry out large-scale attacks against its own people, as we've seen in Syria. The government of the UK doesn't routinely persecute and incarcerate people who dare to speak out against them. So, of course, we recognise that people in many places across the world need to flee. They need to move away from that situation. Where I then end up, however, and where I have sympathy with some of the arguments from many of those on the right of these benches, is that there is a clear and distinct dividing line between when someone is moving away from danger by necessity and moving towards something else by choice. This, I think, is where much of the message is lost and drowned out by noisy activists on both sides, when actually a calm and common sense approach into thinking about this problem makes it very clear. If you're one of those people I mentioned earlier, in danger, living in fear of persecution, incarceration or worse, then of course you must do all you can to remove yourself from that situation and save your life and that of your family. I have absolutely no problem with that. Where the problem lies, however, is once there is no danger, once the fear of persecution or incarceration or worse has passed, movement after that point is out of choice rather than necessity. You're then moving towards something that they consider to be preferable, rather than moving away from danger, because the danger is over. I completely understand the arguments and the confusion as to why people need to move from a perfectly safe country in France. Aside from the occasional street protest and baggage handlers that batter your luggage during the times when they actually turn up for work, France is a civilised and modern and, above all, a safe country, where people are not in danger. So they're no longer fleeing. They're no longer seeking to escape. They are, in fact, moving towards something preferable. And that's where the arguments of those charities and some on the other side of the House sadly lose their credibility for me. But the problem is that once they've made that journey across the Channel, they are our responsibility, and we simply can't send them back unless France agree to take them, which they won't, and why would they? Aside from the fact that they've got no desire to increase their own problem, we've just spent the last decade calling them and their friends everything under the sun and saying that we don't want anything more to do with them. Of course, they're not inclined to help us deal with this problem. So what do we do when we can't just send them back, but have to deal with the situation ourselves? We've heard many speeches and interventions from the other side saying you can't do this and you can't do that, but no one said, actually, here's what we would do instead. Many people have said throughout this debate there's no capacity in the UK. We don't have enough houses for everyone, enough doctors, dentists, hospitals, schools or general infrastructure for our existing population. And they're right. Relocating asylum seekers to a safe third country is a long-established mechanism used all over the world. This is nothing new. What I don't like is this push for a lack of due process, to remove people's rights in favour of speed, expediency and a populist movement. I attempted with Amendments 2 and 3 to balance these competing needs, to allow for appeals, but that those appeals should be heard remotely from Rwanda post-deportation. Seems perfectly possible and feasible to do. If COVID taught us anything helpful, it taught us that we can be a lot more flexible with the use of technology than we have been in the past. Since 2020, courts have been rapidly moving online. The cloud video platform was introduced in response to the pandemic, and a video hearing system is already being used nationally in tax and property tribunals, as well as in Chester Crown Court, not far from my constituency. By all accounts, it works seamlessly. It's a great success. His Majesty's Courts and Tribunals Service plans to transition to a new service of video hearings covering more areas in the future. So it seems perfectly reasonable that this same technology could be able to be used in hearing appeals against asylum decisions. As the government in its clauses 2 and 3 have narrowed the possible reasons for an eligible appeal considerably, it seems that the chance of any eligible claim rearing its head is negligible. So there shouldn't therefore be any reason why individuals cannot continue to be removed but then have their appeal heard from a government-established video conferencing facility in Rwanda. Now, I'm very aware of the established principle laid down in law in the ECHR that people cannot be removed at all if there is an imminent and foreseeable risk of serious and irreversible harm if moved to Rwanda, and that the government quite rightly need to pay heed to that situation, as the UK is very much a signatory to the ECHR, and that situation shouldn't even be considered for change. So, as the Chair of the Home Affairs Select Committee mentioned earlier, it wouldn't be appropriate simply to ignore that rule, and I thank the Minister for his time recently in addressing that concern with me in relation to my amendment and explaining why he didn't feel that it would be possible. I completely accept his explanation and pleased to have had it confirmed by the Honourable Lady earlier, but would hope that there could be a simple common sense approach taken in the aftermath of that. For example, colleagues have said to me that they'd be concerned that women who are heavily pregnant may be able to appeal on the basis of being unfit to fly. Well, I'd hope that the process would recognise that anyone determining themselves fit enough to take a 30-mile journey across a dangerous sea in a barely floating craft that could capsize at any moment can't then claim to be unfit to take a flight in perfectly comfortable and safe conditions. But even if those heavily pregnant women are excluded, the figures show that 90% of those who arrive in small boats are male. Even the leader of the opposition, in his confused state about what that means, would be hard-pressed to find anyone pregnant among that 90%. So it's only a possibility in 10% of the people who come across. And a very small percentage of that 10% of people will be in any state of pregnancy, let alone a stage advanced enough to rule out a flight. The government have rightly narrowed down the possible reasons for appeal so much that I'm astonished that there are still people who are arguing it isn't enough. Once again, we allow murderers to appeal. We remain a civilised society. We cannot simply rule it out. We hear about people wrongly convicted of things all the time. We've spent the last few weeks hearing about a bunch of people who were wrongly convicted in the Horizon scandal. I don't believe for a second that anyone in this House would have denied them the right to appeal. So I implore colleagues not to lose sight of their humanity. The grounds for appeal are so narrow that they will hardly ever apply. Mr Evans, I've spoken for plenty long enough, apart from to say that Amendments 56 and 57, in the name of the Right Honourable Member for Gainsborough, are also eminently sensible and would close another potential loophole. I hope, upon hope, that colleagues will be able to see the wood for the trees in these issues, understand that taking the rights away of appeal entirely would be an affront to our legal framework and not obstruct this bill any further.
Michael Shanks.
Thank you, Mr Evans. It's a pleasure to follow a somewhat slightly more rational contribution than we've heard from a number of members on the other side in today's debate. And it's been an interesting experience, my first committee of the whole House. We've had 17th century constitutional political lectures and analysis of the US Constitution, and I think really interestingly the suggestion from a number of members on the other side, which slightly lets the cat out of the bag, that actually this policy is all about the upcoming general election and how quickly we can get flights off the ground before that happens. Very little about whether this actually contributes to an effective immigration strategy. I rise to speak today in support of Clause 6, and I've spoken in various other debates on this legislation and outlined my objections to it. It's fundamentally a ridiculous proposition, becoming increasingly ridiculous as we see the Tory psychodrama playing out in front of us, slightly less dramatic this time than it was in December, but I'm sure that will change, pulling this bill in two completely opposing directions, while still claiming that it's an entirely workable policy. This has the dubious distinction of being both an utterly immoral and completely ineffective policy, at the same time as costing an extraordinary amount of money, all the while seemingly not even supported by the Prime Minister. And yet here we are debating amendments that will take it even closer to breaching international law, if it doesn't already, and will further diminish Britain's standing in the world. It should be voted down at stage 3, and by the looks of the Tory chaos, it might well be. But for now, we've got an opportunity to try and make this bill a little better with some safeguards. Clause 6, in my view, should be completely uncontroversial. If the government genuinely believes that Rwanda is a safe country, if they believe that it's able to meet all the expectations placed on it in the Rwanda Treaty, then why should there be any hesitation at all in supporting making the Monitoring Committee on a statutory footing, ensuring that Rwanda's status as a safe country can be suspended if the facts change and we uncover additional evidence that perhaps it's not, if the political situation changes, or if the Foreign Office itself changes its travel guidance. Surely these are basic things where we would question the safety of Rwanda. It's on this evidence base that I want to focus my remarks today. Section 2 of the bill is an attempt, as has been discussed, to replace facts with legally binding fiction. The bill might be said to legislate for a lie, to make something that's not true on the evidence that we've seen, true in the eyes of the legal establishment. It was Orwell who wrote, "In the end, the party would announce that 2 and 2 make 5, and you would have to believe it, for the very existence of external reality was denied by their philosophy." We're in this situation here. Forget the evidence to the contrary, just take our word for it. This is fact. So with Clause 6, we have an opportunity to ensure that if evidence were to emerge of human rights abuses or the mistreatment of migrants, there's a mechanism to suspend the government's alternative truth and make legal decisions in our courts on the basis of reality. It's risible that this is even debatable. Given the security situation near the border with the Democratic Republic of the Congo and Burundi, which the Foreign Office on its own international travel guidance today says makes Rwanda unstable, isn't it a sensible precaution to introduce a protection which says that if the FCDO were to advise against travel to Rwanda, the statement that Rwanda is a safe country for migrants should also be suspended? Otherwise, we have a bill that the government seeks to make law which simply says in perpetuity, no matter what, Rwanda is a safe country. The 137 pages of the Home Office's information note on human rights, which it published this week, make for interesting reading. I spent some time reading all 137 pages, and I encourage members to do so, although I wonder how many have. In some ways, when I was reading it, I was surprised the government had actually put it on their website, given the litany of evidence it presents as to why Rwanda cannot, in all seriousness, be declared a safe country. It details examples of state prosecuting political opponents, instances of deaths in police custody, of unofficial detention facilities, of police torture, of ill treatment and torture in custody, of the recruitment of child soldiers as recently as last year, and countless other breaches of human rights law. Questionable also in it is the strength of the Rwandan government's institutions to challenge those breaches. So I do wonder if the government's read their own evidence pack. To add to that, this week, the UN Human Rights Commission has added further evidence, updating just yesterday that the UK-Rwanda scheme does not meet the required standards relating to the legality and appropriateness of the transfer of asylum seekers, and it states is not therefore compatible with international refugee law. It cites numerous concerns about fair and efficient procedures in Rwanda for handling asylum applications, the continued risks of refoulement, and concludes that it undermines the universality of human rights, has implications for the rule of law both domestically and internationally, and sets an acutely troubling precedent. The evidence is clear on the government's own website that Rwanda cannot be defined as a safe country. But even if we were to accept that it was a safe country. Surely this clause gives scope to, in the future, should circumstances change, even if it's the government that decides that, we can suspend the idea that it is a safe country and allow the courts to make their own decisions. Although voting this entire bill down at stage 3 is the right course of action, we should at least try what we can today to make this bill slightly more sensible, to oppose some of the amendments put forward by the other side that take us even further towards breaching our international obligations, and to support amendments that seek to make it slightly more sensible. Clause 6 is a sensible amendment that I would encourage members to vote for. This legislation must be defeated, and the policy it seeks to enact must be abandoned. It's hugely costly and it's ineffective. And with the news this week, as honourable members have raised, of 5 more people tragically killed in the freezing cold waters of the Channel, trying to get their way to this country, it's time to move beyond these gimmicks and the appeasement of the extremes in the Conservative Party and deliver some workable policies.
Sir Simon Clarke.
Thank you, Mr Evans. It's a pleasure to speak in today's debate. I rise to speak in support of the amendments that stand in the name of my honourable friend for Stone and my right honourable friend for Newark, who I believe has shown considerable political and personal courage during the course of this legislation to date. And I want to open my remarks by saying how strongly I believe in the principles of the Rwanda scheme. It is imperative that we break the business model of the people smugglers in a way which means that this trade is not merely dented, but ceases. We've heard platitudes, I fear, from the other side of the House today about how if only we worked a bit more closely with the European law enforcement agencies, everything would kind of resolve itself. And of course, would that was so, and I can testify from my own time in government, but also having spoken to ministers who've been in the Home Office both currently and previously, there is a litany of work which is underway to make sure that we bear down on this evil trade. And it has had some success. Crossings are down by approximately a third on their peak of 2022, and there has been enforcement action ranging from the French coast right through to dinghy sales in Bulgaria, which testifies to the fact that the UK is working at pace with our partner agencies to try and end these crossings. But unless you address the root causes, you will always be left dealing with the consequences of the problem. And that is, I'm afraid, not acceptable to me, but much more importantly, it's not acceptable to my constituents or to the people of this country. Just this weekend, we had, as the honourable gentleman referred to a moment ago, a tragic reminder of the human cost of allowing this trade to persist. But clearly it also has really very serious consequences for the United Kingdom. It makes a mockery of our border security. It damages social cohesion. The accommodation costs alone of our asylum seeker population are somewhere in the region of 8 million people a day, and that's before you go with the through life costs of these people being in this country. And it compromises our security too, as the awful murder in Hartlepool a few months ago made clear. We do not know, we cannot know who is coming into this country, and that is a serious and substantial risk that it is incumbent upon us to acknowledge. So the test that faces us as legislators, as my right honourable friend for Newark has just alluded, is very simple. It is, will this legislation work? It is not, is this legislation the strongest ever? For the record, it is, but it is still likely to prove insufficient. Still less is the test, is this as far as the Prime Minister is willing to go? There is a crisis of faith in our politics, and that really boils down to, as it has done for a number of years now, spanning the Brexit debate and indeed the causes of it, do we as members of Parliament mean what we say? Is our word worth anything? Are we capable, as a country, of asserting our national sovereignty? Are we, as a country, capable of policing our borders? Now, I welcome the fact that the government has decided that we now need to derogate from parts of the Human Rights Act 1998, and that is welcome, it is brave, it is commendable. But we now need to follow that logic to its conclusion. As Amendment 10, in the name of my honourable friend for Stone, sets out, we should set out clearly and unambiguously that this Act will have effect, notwithstanding the Human Rights Act. And we also need to close the loopholes which regrettably remain in the legislation. And we have proposals to do so with an accompanying legal opinion from John Larkin Casey, the former Attorney General of Northern Ireland. And as my Right Honourable friend for Newark set out, I think, very eloquently a few hours ago, we need to strengthen the provisions, in particular, against individual claims, as opposed to the general principle of the safety of Rwanda. It's welcome we are asserting that, but that will be critically undermined unless we can stop the profusion of individual claims which will materialise, not least with the help, I'm afraid, of a creative legal fraternity, if we do not close off this route. Now, contrary to what the Honourable Member for Derren said a few minutes ago, we are not excluding entirely appeal rights. If, for example, you are seriously ill, then you will not be eligible under my Right Honourable friend's amendments for removal to Rwanda. But we do need to make it clear that we are not going to tolerate the abuses, and they are abuses, which we currently witness day in and day out under the current system. We also need to make it clear on the face of the bill that Rule 39 interim injunctions of the European Court of Human Rights in Strasbourg will not have automatic binding effect. Now, this is something which I think many of us regarded as a settled issue, but anyone who watched the Prime Minister's appearance on the Koonsberg show on BBC just a matter of 10 days ago will have seen he was unable to offer that guarantee. He was unable to offer it in good conscience because, of course, here we enter the contested territory of what the Attorney General is prepared to sign off and, indeed, what the Ministerial Code will allow. But this goes precisely to show why this issue is so pressing. If we do not assert it as a sovereign parliament in this bill, then it is highly likely that this issue will rear its head again in the months ahead. Now, failure to close these loopholes will mean that, as my right honourable friend for Newark said, we will face pressing operational problems which will significantly impair and indeed perhaps totally frustrate our ability to pursue what this side of the House wishes to deliver. Our court system will be overwhelmed. Our detained estate for asylum seekers will be overwhelmed. And the public's patience will be exhausted, Mr Evans. We have marched the British public up this hill not once but twice already and failed both times. This is our third attempt. And of course, the government's own estimate, as we know, is that as we stand today, the bill's best chance of success can be rated as around 50-50. That is simply not adequate. We hear today that 150 judges and their courts will be made available to process appeals arising under the legislation. Well, apart from being one of the most effective devices that I can conceive of to worsen our existing court backlog, this is simply confirmation of the scale of the problems that the government itself anticipates as a result of what will happen under the current legislation. I don't know where we're going to find these judges, and it would be helpful if the Minister, for whom, as I hope he knows, I have an enormous amount of both personal and professional respect, it could elucidate this in his remarks. I don't know where we're going to find these judges. I don't know from which cases they're going to be diverted. I certainly don't know at what cost this will all be accomplished, but it is not a tenable strategy for us to set aside such a huge amount of court time when we can act now to prevent what are spurious abuses from being sustained still further. Because, Mr Evans, as my right honourable friend for Gainsborough said, this is our last chance to act in this Parliament. We have tried on multiple occasions, and despite the valiant efforts of my right honourable friends for Whittam, for Fareham, for Newark, for Torbay, Corby and others, we have not succeeded. And it comes really down to the fundamental question of in whose interest do we sit here and do we legislate today? It is clearly, of course, the public interest. And I warned during the debates on Brexit, which I had hoped were relegated now to the annals of history, that this House was playing with fire. If mainstream democratic politicians do not or cannot resolve the problems which face this country, our political process will, I'm afraid, move inextricably to the extremes. And we've heard a lot of rhetoric, and it is rhetoric, from the opposition benches about how extreme the position that we are advocating is. Trust me, it will be as nothing compared to who will sit on these benches if we fail in our task, because we are at the limits of the tenable when it comes to the feelings of the British public. And if the Labour Party win the general election that will be held later this year, which I freely admit the polling at the moment suggests that they will, in large part because of the frustration, frankly, that the British public feel about this issue, they will have to confront these same problems. And if they are not willing to act any more than we have been willing to act, then they themselves will be eaten by this issue just the same. And it is a certainty that this is a beast which we have to slay if it is not to destroy all of the mainstream centre ground of British politics and leave it in the hands of people who will advocate genuinely radical and unacceptable solutions. I will give way.
Friend for giving way. He's making a very, very, very powerful speech indeed. I'm curious, and it's possibly my own procedural unawareness that leads me to ask this question. If this bill doesn't go through tomorrow evening at third reading and it's voted down, is it not the case that within this Parliament we won't be able to bring anything else back on the basis that you can't ask the same question twice that's already been negated? And given that he said it's not an ideal bill and it's flawed and it's 50-50 at best, if he votes it down, it's a 0% chance of anything happening, surely.
Intervening, please look forward, because your voice, mellifluous as it is, can be picked up and the Hansard takers can get it accurately done. Thank you.
Thank you, Mr Evans, and I thank the honourable gentleman for his intervention. It is possible to bring back a bill on this issue, provided there is a substantial difference in what is brought forward and what we are currently debating. And I would argue that a bill which was not focused, as this one is, on the general safety of Rwanda, but on the wider enforceability of our immigration law, could be brought forward in this session. It was a regrettable farce, and I use the word advisedly, in the previous Parliament of which I was a member, that the overt bias of the then Speaker, Mr Burko, meant that we were frustrated when we attempted to deal with this issue in the context of Brexit. I do not anticipate that situation arising in the happy event, and I think it would be a happy event, that the government comes forward with either, well, hopefully it will support amendments to this legislation, but in the event that it does not, it comes forward with a new bill which does go further on these points, so that it can command the support of the whole of the Conservative Party, because I will not give way further on this point. We are keen, as a Conservative Party, clearly, to deliver at this in a way which will actually satisfy the British public. Mr Evans, the Prime Minister has said he will do whatever it takes. Unfortunately, I do not believe that as of this moment we are set to do whatever it takes to stop this problem. And I can only vote for this legislation if I believe genuinely and sincerely that it will resolve the problem. If I can look my constituents, the people who send me here, in the eye and say that this is going to fix it. Because I've already done so twice before, and I've let them down. So I urge my colleagues to reflect carefully on this. The Prime Minister has confirmed the general election is likely to be held in the latter half of this year. By that time, there will have, I'm afraid, been a contact between this bill and the reality of our court system, and I don't think the outcome will be a pretty one. There will have been time for it to be tested, and I fear there will have been time for it to fail. At best, as my right honourable friend for Newark has observed, we are likely to see a few token flights setting off, not the kind of automatic deterrent which is going to be required in order to really change the incentives. If you are a young male who is, in essence, an economic migrant in all but name, seeking a better life in the UK, the expectation needs to be that you will be detained and that you will be removed, and that alone is what will change the incentives driving this trade. That is not what is set to be delivered by this legislation. And in the absence of amendments being brought forward and supported by the government, I will not be able to support this bill. More than that, I will vote against it at third reading. And I say that with real sadness, but also total determination that we, as a Conservative Party, should show that we are honest with the British people about the nature of the crisis that we face and that we're determined to do everything in our power to resolve it. Short of that, as I say, this legislation cannot have my support.
And I rise to speak to the amendments tabled by my friend, the member for Stone, and also the Right Honourable member for Newark. Those of us who are not learned members in this place have had very interesting conversations over the past weeks and months with learned colleagues on both sides of the arguments around this bill, with suggestions. Some want it toughened, some want it slightly softened. But all of us are united in wanting a bill that works and allows the Prime Minister to deliver on his promise. And I absolutely trust the Prime Minister's commitment to ensuring we can stop the boats. I believe that the Rwanda policy can be a deterrent to people. If your expectation is you won't succeed, you don't have a right to remain in the United Kingdom, you will not pay your money to the person that promises that you can. So I am grateful to those learned colleagues for putting forward their opinions. If it has shown me anything, it is that lawyers like to talk and argue. And it is in their interest to talk and argue. And what we cannot have is a bill that goes forward and passes that enables lawyers to bat cases around indefinitely, to allow appeals to be lodged, to be enough to make this policy ineffective. Because my constituents, Mr Chairman, they just find it ludicrous that they elect members to come to this place and to act in their interests, and we don't seem to be able to do it. On this issue is raised with me, I think, more than any other on the doorstep. The small boats trade, it is an evil practice on so many levels. These are people making money from people's misery. They are people putting lives at risk. And also, it is perverse. I've spoken about this before. A fair and just asylum system is not reliant, or should not be reliant, on your ability to scramble across a continent, to scramble thousands of miles, and to pay people, smugglers. It is absurd to any rational person. And I will give way. I'm happy to give way.
She's saying that there's limitations of the asylum system, but would she accept that the only way that you can legally claim asylum in the United Kingdom is to put your feet on these shores? There is no asylum visa, and the government has not proposed any new safe and legal routes to allow people to come here.
I thank the honourable member for her intervention. Another absurdity my constituents raise with me is why they listen to opposition parties who seem to speak only for the rights and the interests of 8 billion people in the world, above the rights of the people who elect us to come and serve here. And I would invite her to re-intervene again, because I don't ever hear a sensible limit. There are undoubtedly many, many more people, and I will come on to international development later on in my remarks. There are many, many millions more people that would have the right, under the current framework, to claim asylum here than we could ever possibly hope to accept into the United Kingdom. And if she has a number that she thinks is a limit or would be unacceptable, at what point is this argument exhausted? I'm happy to give way.
Because her point is really quite absurd. Nobody is saying realistically that 8 billion people are coming to the UK. The vast majority of people who do flee their country stay in a neighbouring country. They don't go any further than that because they want to return home. The UK takes a very small percentage of that number, and those people that come quite often come to reunite with family and for safety, because there are people who are already here who can help to look after them and support them.
The Honourable Lady, I just fundamentally disagree with her. I think that my constituents would also, I think Scotland doesn't have the same issues that many English places, and I don't think Scotland has taken its fair share of asylum seekers over the past months as well. But I think globally we need to have a bigger reality. Our responsibility now in this place is to look forward. And the Rwanda Bill, I do think it will be a deterrent. I do think if it succeeds, it will put people off making those perilous journeys and breaking this evil, perverse model of people smuggling. But I think we do need to look at the bigger, wider framework as well. I had a really interesting visit to Washington last year. I met with many people. I met with the World Bank. And if anyone hasn't read their report last year on global migration trends that they anticipate over the coming decades, I would invite them to go and read that. We also met the United States Agency for International Development. And my profound belief is the answer for the world is not to empty less affluent bits of the world into the stable, affluent bits. It clearly, mathematically, if nothing else, it cannot work. And so our focus, I think this is a moment for us to consider a much wider picture and to question the whole framework, much of it devised for a European issue 70 years ago. We are living in a very, very different world where information 20 years ago was not available to people living in developing countries. The internet wasn't there. They had no idea how to get from point A, how to get to point B, who to pay, what to say when you arrive, what you can expect when you arrive. We are living in a totally different world. And I welcome the Prime Minister's commitment to deal with us. In December, he spoke to the Fratelli d'Italia at a conference in Rome, and his words were quite clear. And if I can find them, they're going to be marvellous. He said, in order to break the business model of the criminal gangs, if that requires us to update our laws and lead an international conversation to amend post-war frameworks around asylum, then we must do that. Because if we don't fix this problem now, the boats will keep coming and more lives will be lost at sea. I wholeheartedly agree. I am well known in Wolverhampton for telling my Labour Council to get a move on. And on this issue, I'm going to turn my fire briefly and in a very friendly way on the Prime Minister. He should get a move on with this. He should be leading that global conversation. It is one that so many countries are ready to have. The United States is ready to have it. Most European countries, they are looking to our policy. They're looking to see if it will work, but they accept the mathematical reality, the social reality, and what our constituents want. Mr. Chair, I will conclude. I don't want to speak at great length, but I want to thank all colleagues who are trying to strengthen this bill. I want it to be as robust as it possibly can be, because we need it to be fit for the crisis that we face. It is a crisis, and my constituents certainly want to see results on that crisis. So I will support these amendments. And I also want to put on record my wholehearted thanks to the Prime Minister for his determination to sort this out.
And after Miriam Cates, Matt Warman will be the last speaker, just to give an indication to people that the wind-ups will then begin, or the government response straight after Matt Warman sits down. Miriam Cates.
Mr Chairman, and it is a pleasure to follow my honourable friend, the member for Wolverhampton. It was a fantastic speech, and I think the honourable member got to the grips with the heart of the issues here. Now, I rise to speak in support of the amendments in the name of my honourable friend, the member for Stone, and my right honourable friend, the member for Newark. And I want to speak particularly to the amendments in the name of my right honourable friend, the member for Newark, amendments 19 to 22, which are amendments to clause 4 of this bill. Now, these amendments taken together would prevent individual migrants from blocking their removal to Rwanda by using the UK courts to make claims over months and even years. Now, this bill already does block off claims related to the general safety of Rwanda in particular, but it doesn't stop individual challenges like those that did indeed stop the flight in June 2022, the flight that ended up with the case that came to the Supreme Court last year. Now, the bill as drafted states that for an individual to avoid deportation, there must be compelling evidence that they would come to serious and irreversible harm if deported to Rwanda. Now, this sounds like a very high bar. But in reality, all that would be required would be a doctor's certificate certifying mental health problems if this person was taken to Rwanda, for example. And indeed, that is what happened in June 2022 to a couple of dozen of people sat on that flight on the tarmac. Now, nothing materially in this bill changes that fact in terms of the individual claims. Now, even if those claims are not accepted eventually, they still clog up the courts. They can still end up in appeal, and as we've already heard from other speakers, that can be a matter of years. Now, the government has said last night that it will increase the number of judges on these tribunals by about 150, I think. But all that shows is that the government is expecting a large number of individual claims. So if this bill, as drafted, blocks off those individual claims, as the government suggests, then why would we need those additional judges to move through the courts? And I think the questions raised by my right honourable friend, the member for Middlesbrough, about where those judges would come from and what impact that would have on our wider court system are very valid. But if there are those individual claims that are clogging up courts for months or even years, then even if they are not ultimately successful claims, it will automatically weaken the deterrent effect of the bill and of the plan. And of course, the whole purpose of the Rwanda plan is to be a deterrent. And deterrents only work if the same action is always followed with the same response. Yep. If it's always consistent, it's the same in the criminal justice system, it's the same in parenting. Effective deterrents are by definition fair. They treat everybody equally. And some of those opposing these amendments are normally highly in favour of equality. But actually these amendments make it equal. Everybody who arrives here illegally will be detained and be deported. That is how we create an effective deterrent. Now, I readily admit that the government has made progress, and I warmly welcome all the progress that has been made, the deal with Albania, the upstream work with Bulgaria, the attempts to help the French prevent more of the boats from launching in the first place. But to actually stop the boats, which is the Prime Minister's pledge, which is the pledge that we have made to our constituents and made as a party, then migrants in Calais and the international criminal gangs must know beyond doubt that anyone arriving illegally in the UK will swiftly be detained and deported. And my honourable friend for Wolverhampton is absolutely right. These criminal gangs and migrants have smartphones. They have the ability to tell instantly which routes are available, where the boats are, how much they have to pay, what different countries' asylum system looks like, what different countries' benefits systems looks like. We have an instant trade in information. So the only way a deterrent can work is if everybody knows beyond doubt that that is exactly what will happen to everybody landing on our shores. I certainly will.
I thank my honourable friend for allowing me to intervene, and I'd like to commend her for all of the work that she's been doing on this. Would she agree with me that the reason we need to strengthen these particular clauses, and why I will be supporting the amendments, is because the whole point of people, majority of people coming here illegally, is to claim asylum so that they can actually stop any deportation possibilities. And Home Office's own figures show that when that process has happened, 70% of those people are absconding, and we need to stop this now. Would she agree with me?
I thank my honourable friend for her intervention, and yes, I absolutely agree, and I think this is the problem, is that Britain has become known as a soft touch, partly because of the delays in our courts, partly because of the generosity of housing migrants in hotels, our very high acceptance rate of asylum seekers compared to other countries. So in order for the bill to be effective, an effective deterrent, we have to close off those limitations of the current scheme by making sure that everybody who arrives here illegally is swiftly detained and then deported. That is the only way to get an effective deterrent. But of course, what these amendments are arguing is that individual migrants should not be able to make suspensive claims. So they should not, in this country, in British courts, be able to claim against deportation. But they would still absolutely retain those rights when they arrive in Rwanda. We're not talking about removing those individual rights to claim for asylum, even to be sent back to the UK in some circumstances. Those rights still are retained, but it's essential that they happen offshore in the third country of Rwanda, because it is the deportation that is the deterrent. So that's why these amendments are absolutely needed for all individuals, except of course those who are unfit to fly or where obvious mistakes have been made. Of course they should not be put on planes to Rwanda, but to be consistent for all others to be sent to Rwanda. So as I've said, the point of this is a deterrent. Now, but there is strong opposition to these amendments, clearly on the benches opposite, but also amongst many on these benches. But I would draw honourable members' attention to a poll published in the Telegraph last night that showed that swift detention and deportation is the most popular choice in almost every single constituency in the country for dealing with illegal immigration. It is the preferred option for a large proportion of the general public. And whilst various interpretations of international law and its application might be highly contested in Westminster, as we've heard today, the need for secure borders is really not a contested idea in the country at large. The British people are generous and compassionate. They support managed schemes to welcome refugees, as we've seen over the last few years. But the British people look at tens of thousands of mostly able-bodied young men coming from a safe country, France, taking physical risks to cross the world's busiest shipping lane in a dinghy, then being housed in a hotel at great expense to them, the taxpayers, some of these people absconding, some committing horrific crimes, and then they listen to Westminster commentators saying that because of international conventions we can't deport these people, and they say, are you serious? Are we serious that we can't do that? Most ordinary people in this country don't lie awake at night worrying about our standing amongst elite international lawyers. They lie awake at night worrying about security and crime and the cost of housing, all of the issues that are made significantly worse by the abuse of our asylum and immigration system. Because without doubt, our system is being abused, and it will continue to be abused unless this bill is strengthened to limit those suspensive claims so that all people arriving on our shores illegally are treated the same, detained and deported. Because, Mr Chairman, I'm afraid weaknesses are always exploited. It's a sad fact of history and human nature. And those that don't believe this, I'm afraid, are naive, and we must deal with the reality. And the honourable member, the right honourable member for Gainsborough, put it very well. Many of us would behave exactly the same in those circumstances if we saw what was available in the UK, compared it to a life in a particular country, elsewhere in the world, knew that it was easy to come here, to tie up the courts for a long time, potentially abscond. Many would do the same. It's human nature. So the reality is what we have to deal with, and I think it is a matter of responsibility. The responsibility of the British government is the safety and the welfare of the British people. It's not our responsibility to rehouse everybody else in the world who would like to leave their own country and come to ours. Now, we can absolutely sympathise with their plight as individuals, but it's simply unrealistic to say that the UK has a responsibility to any asylum seeker anywhere in the world who would like to come here. We have responsibility for our constituents. Other governments have responsibility for their constituents. If they are not engaging with that responsibility correctly, that is not our fault. Yes, I will get more.
I'm grateful for giving way. Would you agree with me that a focus on foreign aid, a united sort of effort to really make effective, thank you for shouting at me, a united focus so that developing countries, safe developing countries, benefit from giving these people asylum. They can make good lives there, they can have education, good prospects for their children. This is the way forward rather than sort of mass flux into the UK.
I absolutely agree with my honourable friend, and of course she's right. One of the many solutions to this problem is to improve conditions in some of the countries from which people are fleeing. But we also have to be realistic. We cannot solve all the problems in the world, and we are speaking about illegal migration. But there are also ethical issues with legal migration. If we're taking a large number of well-trained, well-educated young people from developing countries to our NHS, to our workplace, That's not helping the countries that they're leaving either. So I think the whole immigration debate does need careful scrutiny, the ethics of it in both directions. But I'll come back to my point. Yes, we should be compassionate. Yes, we do need to have schemes for taking refugees, well-managed schemes. But it is not the responsibility of the British government to rehouse everybody in the world who would like to come here. That doesn't mean we do not have sympathy for individual plight. But the definition of responsibility and accountability matters, and our responsibility is to our constituents and first and foremost the welfare of those in the UK. So, Mr Chairman, I do support these amendments. I will be voting for them tonight because the bill must work. It must work to provide an effective deterrent. It must work to secure our borders. It must work to prevent people smuggling. And it must work to show the British people that their elected representatives really do take their concerns seriously.
Yeah. After Matt Warman, we have the Ministerial response and then Alison Thewlis to make references to her amendment, and then we are expecting multiple votes. Matt Warman.
Thank you, Mr Chairman. I want to begin by talking about the remarkable contribution of the Honourable Member for Stone, to whose amendments I want to speak. In a constituency like mine, which voted so overwhelmingly for Brexit, the work that he has done over many decades is something that is appreciated. It is something that has been has served the national interest, and it makes me somewhat nervous about criticising Amendment 10. But nonetheless, I know that more than anything else, he and I can disagree courteously, which is perhaps more than I have managed with some, more than all of us have managed with some Brexiteers who have got perhaps too much credit for a project that has now run its course. Because I could talk a little bit at the beginning of this about why I worry that a bill that is already judged to have a 50-50 chance of success could be, in the pursuit of toughening it up, driven to have a far lesser chance of success. So people who say that they want it to work and they want it to work quickly, in fact run the risk of driving it into the courts, seeing it fail, seeing us as a party take less action that is so clearly in the national interest.
Has my honourable friend, having looked at my amendment very carefully, observed that actually the only way you can guarantee that this bill will be satisfactorily regarded by the courts is if the sovereignty of an Act of Parliament is combined with clear and unambiguous words. That improves the bill. It doesn't mean that it won't go through. It means that it will go through and the courts will accept it.
I would agree with him that it could go through. It doesn't guarantee legal success, as he knows. And while he is right that there is a respectable legal argument to be made for it, a respectable legal argument is not something that guarantees success. And I want to see, not least because of the poll that he cited and others have cited, us take clear and effective action on this. And if we are to take clear and effective action on this, it has to be successful. It has to be able to survive those potential legal challenges. So the reason I argue in favour of the tightrope that the government is walking is not because I lack conviction, it's because I want to see action as quickly as possible on an issue that I hear from my constituents day in, day out, has a clear and real impact on their lives. Only yesterday, the Home Office announced that it was closing another 2 hotels in my constituency that are currently being used for the housing of asylum seekers. But that migration crisis, that global migration crisis, is on the doorsteps of constituents in Boston and Skegness today. That is why we have to tackle it, and it's why we have to tackle it effectively. So I will take no lectures from anyone in this House on my personal commitment to tackling this issue, but that is why I want the government to stay on its tightrope and to get on with addressing this vital matter. But I want to make one separate point, which is about the nature and the signals that I fear an amendment such as Amendment 10 would push this country into. And that is to say, in Amendment 10, that we would be able to ignore more of the ECHR, more of the Refugee Convention, more of a whole host of international agreements that this country helped to write. And this country surely having helped to write them 70 years ago, has a duty today, as my honourable friend from Wolverhampton said, to see them reformed and to see them improved. Because the Refugee Convention, if you go to Spain, to Germany, to Italy, to France, they don't think it's working for them either. I don't think it's working for this country or for my constituency. I want to see it reformed and improved because more than anything else, things like the Refugee Convention today, right now, aren't working for refugees. And the place of this country, the role of this great country, surely should be to stay at that table and to say we have got to work within a global system. The ECHR, the Refugee Convention, a whole host of other international agreements need to be better. We've seen some existing positive reforms already, but we can see more if we stay at that table. If we say that we should not see those rules apply to us, we send a signal that we are stepping back from that conversation. We say that we resile rather than want to see reform. We say that we want to back out rather than back ourselves in having a place in the world and a place at that table. I would happily give way to him again.
I hope he did notice that I did say that changes in those laws in the European Union, which has the Charter of Fundamental Rights, as well as in the European Court of Human Rights, is going to lead ultimately to constitutional referenda, amendments. It's going to not only take a long time, but it may well be actually impossible.
I fear that some of what he says is correct, but it is also true that we lessen our ability to make that case on our own behalf and in the global interest if we step back from those. And I want to see Britain leading that conversation, having its place at the table, and if we can do that, we will be able to construct a global system today, just as we did 70 years ago, that worked then. We need one that works now. And the more we send a signal that says Britain steps back from that, the less we have the right to make that case. And making that case is what is in the interest, surely, of all of our constituents. Yes, he's right that it will take a long time, but he's also surely got to acknowledge that we have to have that long-term view, because this is a global migration crisis that is going to be with us for decades. And if we step back, then we have less of a right to influence that. I'll give way to my friend from Grimsby.
I thank my honourable friend, a near neighbour, who's, I'm sure his constituents are very much in the same frame of mind with my constituents, of how illegal migration is having a detrimental effect on our communities. But, you know, would he agree with me that that is why it's so important for us to be able to have these wider discussions and for government to take amendments really seriously, because it's by only having these robust discussions and those options and those amendments that we want the government to look at, that actually we can get to the place that he's talking about internationally.
I agree with her up to a point, but the government can only go so far before it lessens its chances of getting this bill actually through successfully in terms of potential legal challenges in the future. So this is about the practicality of delivering a bill, and it is about delivering Britain's place on the world stage that we surely should say is something that allows us to continue to play a leading role in reforming those vital conventions and those vital international agreements. So I think fundamentally, does this bill work? Does it go as far as it possibly can without fundamentally jeopardising its chance of legal success? Yes. It walks a tightrope. And I know that my honourable friend from Newark says that there is legal advice supporting his position. I would like to see that legal advice, and I'm sure the government would as well. But that practical issue of can this bill work is a tightrope that the government has to judge. And I accept that this goes as far as it possibly can. In some ways it goes too far for me. We've heard some members on this side of the House say that it goes too far for them, but they are prepared to support it because that is how important this issue is. But beyond that, the issue of where is Britain's place in the world, what is our role in our ability to say that we can help shape a new set of conventions that work not just for us, not just for countries that share our values and share this problem, but also for the countries that people are fleeing from, because it is that global system that we have an opportunity to reform and where we lessen our ability to do so if we say that we are able to stand apart from its rules. It is a balance we can strike, and I believe if we are optimistic about Britain's future place in the world, we should be saying we stay at that table, not that we resile from it. And that is why I'll be supporting the government in seeking to rebuff these amendments tonight and trying to get on with addressing this vital issue, because it will establish Britain as a country that is committed to those commitments that we made some time ago and helped draw up. But it will also demonstrate that we are committed to go as far as we possibly can in pursuit of challenging what is a vital issue that affects all of our constituents. And I look forward to the government winning this vote this evening.
Yeah.
The Wind-Ups Minister.
Mr Evans, what a great pleasure it is to follow my honourable friend, the member for Boston and Skegness. I think it's the second time that I have done so in this bill, and it's a great pleasure. I'm going to try and emulate his courteous exchange with colleagues. I enjoyed his exchange with my honourable friend, the member for Stone, and with his near neighbour as well, because it is with such courtesy that we can still have a robust discussion about this literally vital issue. Mr Evans, it's been a wide-ranging debate, and I'm grateful to all honourable and right honourable members for their contributions. First, as the honourable member for Glasgow Central had the lead amendment, I want to start with some overarching remarks in response to her amendments first. But Mr Evans, this House has a fundamental choice. We can legislate, as the government proposes, to end the perilous journeys being made across the Channel by enabling Parliament to confirm that in light of the treaty that the Home Secretary signed on the 5th of December of last year, and in light of the updated evidence that the Republic of Rwanda is a safe third country, or we can put into statute a scheme that is riven with holes by amendments tabled by honourable and right honourable members opposite that makes the bill simply unworkable. Mr Evans, the new legally binding treaty with the government of the Republic of Rwanda does in fact respond to the concerns set out by the Supreme Court. It also reflects the strength of the government of Rwanda's protections and commitments, both to this scheme and to the rule of law. And I'm going to return to that point later on in my speech. But, Mr Evans, let there be no doubt that the government is focused and determined to stop the boats. We have made progress, but we must be enabled to finish the job. May I start by turning, please, to Clause 2. And this clause creates a conclusive presumption that the Secretary of State, immigration officers and courts and tribunals must start from the basis that Rwanda is safe. And it is right to say that it will not send someone to another country in breach of the Refugee Convention. The Supreme Court's ruling on the Rwanda policy recognised that changes could be delivered in the future which could address the conclusions they came to. And we've been working closely with Rwanda to address those issues. And when considered together, the treaty, alongside the evidence, and Mr Evans, I want to come back to the evidence and some of the points that honourable and right honourable members have picked up during the course of this debate later in my speech, but alongside that evidence of changes in Rwanda since the summer of 2022, it means that we can confidently conclude that Rwanda is a safe country. I'll be delighted to give way.
For giving way, if then Rwanda is a safe and secure place in which asylum seekers can live comfortable and productive lives, why should the prospect of being sent there be a deterrent?
The deterrent is because those are seeking to come to this country and not to the country of Rwanda. And I hope he listens to some more of the evidence that I'm about to set out. He sat through a fair amount of this debate, and I always enjoy taking interventions from him. But I'd encourage him to consider the evidence and some more, as I progress during the course of the speech. How could I refuse?
It is simply this, that as he heard, I made reference to the Rwanda judgment and the case of ASM, whose claim was dismissed because, in a nutshell, of the sovereignty of Parliament in the context of immigration laws which were revoked under the Retained EU Law Act. That is a very perfect example of what the courts will do under paragraph 144 of the judgment. Does he accept that it is the sovereignty of Parliament which led the court to make that decision as they stated themselves?
As my honourable friend knows, he and I agree on a great deal, and I have paragraph 144 engraved on my heart, and we've had a number of exchanges about that. And it is clear that the court will not disregard an unambiguous expression of Parliament's intention as set out in paragraph 144. And I'm going to come back to my honourable friend a little bit later on during the course of my speech. But since the evidential position considered by the courts in the summer of 2022, there has been further specific information, further evidence and assurances from the government of Rwanda that explicitly addresses the challenges raised by the claimants and the UNHCR in the litigation, and also the findings of the Supreme Court following its judgment in November. And my right honourable and learned friend, the member for South Swindon, mentioned the evidence and the importance actually of looking at the evidence, and it's worth setting out some of that here, at least in outline. First of all, the headlines from the world rankings, Mr Evans. The World Economic Forum Global Gender Gap Report ranked Rwanda 12th in the world for gender parity. Interestingly enough, it ranked the UK 15th. Secondly, Rwanda's overall score in the World Justice Project's Rule of Law score has increased consistently from 2019 to 2023, and Rwanda ranks first in its region and 41st out of 142 globally. I want to come back to that because that's an important point and there's more detail there. And the World Bank Group scored Rwanda at 16 out of a maximum score of 18. That's just some of the evidence. The government has also published a policy note. It published that on the date of the second reading, and it's been updated this month. There are country information notes on the Rwanda human rights, on the Rwandans' asylum system, on the government of Rwanda's evidence, on the UNHCR evidence, and a lot of that evidence is substantial and helpful, but we haven't cherry-picked evidence, unlike some, I hesitate to say, some members have. There's also been other material that has been published as well. And it's worth considering that evidence because that is what has changed since the summer of 2022. Of course I give one.
And perhaps I'm being facetious in this, but perhaps seeing as though so many illegal migrants are fleeing France, perhaps we should now start thinking about a Safety of France Act next.
Well, my honourable friend might have been a touch facetious during the course of that, and she herself said it, but otherwise I wouldn't have dared to say it to my honourable friend. But I understand what she says. Suffice it to say, Mr Evans, we are confident in the safety of Rwanda, and the aim of this bill is to prevent domestic courts and tribunals from considering claims that relate to the general safety of Rwanda. Hence Clause 2, hence the points that my right honourable and learned friend, the member for South Swindon, mentioned about the evidence, about the treaty, and about the fundamentally changed situation. Turning to the honourable member for Glasgow Central and her amendments. She's right, the amendments seek to undermine the core objectives of this bill. She's been straightforward about that, she's nodding. We are agreeing yet again during the course of these exchanges. It'll do nothing for her street cred in her constituency, but we are agreeing at least on that point because her amendments would undermine the provisions aimed at narrowing the grounds through which people can challenge their removal to Rwanda through courts or tribunals. The treaty agreed by both countries makes it crystal clear that asylum seekers sent to Rwanda are not at risk of being returned to a country where their life or freedom would be threatened, known as refoulement. And Mr Evans, Article 10(3) spells that out very clearly. We therefore do not accept, and this also relates to Amendments 35 and Amendment 37, tabled by the opposition, we do not accept that there is any risk of refoulement given that article, given those reassurance, and given the treaty. I will also remind honourable members opposite that the government of Rwanda, the African Union, the UNHCR have signed an agreement to continue the operation of the Emergency Transit Mechanism Centre in Rwanda, and by temporarily accommodating some of the most vulnerable refugee populations who have faced trauma, detentions and violence, Rwanda has showcased its willingness and its ability collaboratively to provide solutions to the refugee situations and to crises. The policy statement that was published by the government set out further evidence on this very point. And Mr Evans, it might just be worth for a moment or two dwelling on that, because in November 2021, the government of Rwanda set out the details of the emergency transit mechanism, and this agreement has attracted EU funding, and that will support the operation of the ETM until 2026. And Mr Evans, on the 9th of February, the EU announced a €22 million support package to this scheme, which the European Union ambassador described as a crucial, life-saving initiative to evacuate people facing major threats and inhumane conditions in Libya to safety in Rwanda. It is a significant example of African solidarity, of partnership with the European Union. And I continue with the quote, "We are grateful to the government of Rwanda for hosting these men, women and children until such time durable solutions can be found." Yet further evidence, Mr Evans, of the safety, not in the future, but now, but currently, the hundreds of thousands of refugees that Rwanda is welcoming and hosting and has done over the years. May I turn to my right honourable friend, the member for Gainsborough. I'm grateful to him for tabling his amendments. I listened intently as he spoke. The bill only allows the decision maker to consider whether the Republic of Rwanda is a safe country for the person in question where the individual has presented compelling evidence relating specifically to the person's particular individual circumstances, and only where their claim does not relate to the risk of onward removal from Rwanda. Mr Evans, we all share my right honourable friend's desire, but this is already a high bar, both legally and evidentially, for making a successful individual claim, and Clause 4 sets that out. If people try to use this route without compelling evidence, they will have their claim dismissed by the Home Office and they will be removed. My right honourable friend mentioned people concocting evidence and mentioned fabricating evidence. But of course that is the exact opposite of compelling evidence. Concocted evidence cannot amount to compelling evidence. It cannot be merely a bare assertion. It cannot even simply be a tweet as he set out. May I turn to my honourable friend, the member for Delyn. I'm grateful to him for his amendments. I'm grateful to him for his exchange and engagement, and also for his constructive remarks. In relation to his Amendment 1, and he was the first out of the blocks to get an amendment in relation to his Amendment 1, I'm grateful for the way he set that out. We do assess that Rwanda is safe for those that are being relocated there for the reasons that I have given. But the terms of the treaty that we have negotiated with Rwanda addresses the findings of our domestic courts and makes specific provision for the treatment of relocated individuals, guaranteeing their safety and their protection. And the implementation of these provisions in practice, it will be kept under review, exactly as he's been asking for. The Independent Monitoring Committee will look at it. Their role was enhanced by the treaty, and they will ensure compliance with the obligations agreed. I'd also say to him it's worth considering Article 4 of the treaty, because that means that in many scenarios, as is already the case, the government can and will adapt and respond as necessary. May I say to him about his other amendments? It is right that it cannot consider an individualised claim to the extent that it relates to whether Rwanda will or may remove or send the person in question to another state in contravention of its international obligations. That is already there, and there is only an extremely limited route for individual challenge. However, I would say to him that removing judicial oversight until after a person has been removed to Rwanda in its totality and preventing interim relief, even if they can show, however unlikely, a real imminent and foreseeable risk, is unlikely to be compatible with convention rights. It's important to note, Mr Evans, that just this week, in fact last night, the House passed legislation to add both India and Georgia to the list of safe countries to which we will be able to return nationals with no right to be here. It's also right pointing out that the Labour Party are so divided on that they couldn't even agree amongst themselves that India and Georgia are generally safe countries, and it's no wonder they can't formulate an immigration policy. But may I turn, in fact, to the World Justice Project's Rule of Law Index on that. I'm going to turn actually to some of the evidence, to the Rule of Law Index from 2023, which mentions Rwanda, in fact mentions 142 countries, listed from all the way from the top to the bottom, from Denmark at number 1, all the way down. It's important to note that in relation to Georgia, that the House has already declared to be a safe country, they appear as number 48 on the list. India, number 79 on the list. The House has already passed legislation confirming that they are safe countries. Vietnam...
Very grateful for the Minister giving me on that point. On the point of India, Jagtar Singh Johal has been detained now for over 6 years. Is he saying that India is a safe country for every UK national?
No, I'm saying that this House has passed legislation last night that India is generally a safe country for the purposes set out in the legislation. And I'm pointing out to him, and I'm grateful to him for listening, to him and to other members who are listening, that India happens to be 79 in the global rankings. Vietnam, where we regularly return citizens to, is 87. Albania, we've mentioned Albania, I'll come back to it and mention it again, is 91. And Rwanda is 41st in that list. Comparables, marginally lower down the rankings than Poland, comparable to Romania, higher than Croatia, Greece, Bulgaria, Hungary, and all these other countries that are safe, that are strong international partners of this country. That is the evidence that has been published. That is the evidence that is before this House. And that evidence compellingly shows that Rwanda is a safe country. Could I turn now to Amendments 19, 20, 21 and 22 and Amendments 10? And may I thank again my right honourable friend, the member for Newark, for his engagement, for his remarks and for what he said. He is absolutely right. He set out the moral imperative that we need to act, that we need to limit individual claims, and I agree with him that we must focus on what works. In terms of my honourable friend, the member for Stone, as I said earlier, I agree with much of what he says. He's right about dualism. He's right about sovereignty. We may indeed debate sovereignty again tomorrow when we come to Clause 1. And indeed, there's a lovely accord between my honourable friend, the member for Stone, and my right honourable and learned friend, the member for South Swindon, on the very points of sovereignty, and doubtless we'll debate that again. Where I respectfully disagree with him is in his assessment as to whether it will work. As drafted, Mr Evans, this legislation is clear. It is unambiguous, and as drafted, Parliament is setting out the law clearly, and it will work. May I turn to my right honourable friend, the member for Middlesbrough South, and of course I'll give way.
I merely repeat the point that parliamentary sovereignty has to be combined with clear and unambiguous words. The words notwithstanding are hallowed. They're in the Withdrawal Agreement Act 2020. That makes it absolutely clear. Otherwise, it is not clear, and the courts can rule against us, as they did conversely in relation to the Rwanda judgment, where they agreed that clear and unambiguous words are necessary and indeed essential with regard to claims under matters relating to this bill.
I'm grateful to my honourable friend for his intervention, and I agree with him. He is absolutely right in relation to clear and unambiguous language. However, Clause 2, as drafted, is clear and unambiguous. If I may say so, it's simply a different way of saying the same thing. Either you have a deeming clause that deems Rwanda to be safe, or you have a notwithstanding clause. Actually, Clause 2 has the joy of having both. It has both a deeming clause and also a notwithstanding clause as well. It is clear, it is unambiguous, and the courts will follow it. Turning to my right honourable friend, the member for Middlesbrough South and East Cleveland, I agree with him. He passionately believes that this is the right policy. I agree with him when he said that. He mentioned that it's important to tackle the root causes. He is right. He mentioned we must not allow this evil trade to persist again. I agree with him entirely on that. He asked about the courts and the tribunals, as indeed did the right honourable member, the chairman of the Select Committee, as also did my honourable friend, the member for Penistone and Stocksbridge as well. They asked about that. There was, in fact, a written ministerial statement that was laid earlier on today. I would encourage him to consider the detail of it. He's right that more judges are being recruited. It is important to say that deployment of the judiciary, of course, is a role for the independent judiciary. That is absolutely right to say. But more are being identified and trained, and I would encourage him and other honourable and right honourable members who mentioned that to look out for the Lord Chancellor's statement that was published today, that written ministerial statement. Yes, of course.
I ask the right honourable gentleman to clarify how, if the government can find as many as reported in the Times and Telegraph, 150 extra judges, if we could divert that judicial capacity to maybe prosecute some alleged rapists or murderers here in the United Kingdom. Could he clarify and exemplify what he actually means, and if those reports are actually true?
Well, I'm grateful to my honourable friend for that intervention, and she's right, and I sense, understand and share her passion for not only resolving the issues in relation to the tribunals, but the courts as well. And I know her background and her passion for ensuring that the court system and the backlog is dealt with, and she knows my position on that as well. I would encourage her to look at the detail of the written ministerial statement that the Lord Chancellor does set out, and it's right to say that this is in response to the Illegal Migration Act that my right honourable friends, the members for Newark and for Fareham, passed and took through this House. And it's right to say that it's there to ensure that there is capacity within our tribunal system. And I entirely agree with her, and there was an exchange on that during the course of the debate, that we must make sure that that is there in our court system as well. May I turn? Yes,
I thank the Minister for giving way. Just before he moves off the contribution of the right honourable member for Middlesbrough South, I intervened on him to say that it was my opinion that if this bill was voted down tomorrow at third reading, because this would be an issue that the House had already dealt with, no similar bill would be able to be brought back again. And he was of the opinion that a substantially different one would be able to be brought back. The problem that he has is that if this House declines all of the amendments, which it is entirely likely to do, then presumably any future bill that's brought back would include all of those amendments, and therefore the House will have substantially dealt with all of those issues. So if this bill is voted down tomorrow, it won't be able to come back in any form.
Well, my honourable friend will appreciate my determination to get this bill through. I am the Bill Minister for this bill, and it's my determination to get this through today and tomorrow and through its further stages. May I turn to my honourable friend, the member for Wolverhampton North East, and thank her for her constructive speech and for the constructive tone that she adopted during the course of the debate. She is right. We are united in wanting to make this scheme work. I'm very grateful indeed to her for mentioning the Prime Minister's words in Italy, and they bear repetition. If we do not tackle this problem, the Prime Minister said rightly, the numbers will only grow. If that requires us to update our laws and lead an international conversation to amend the post-war frameworks around asylum, we must do that, because if we don't fix this problem now, the boats will keep coming. She was right to echo those words, and I'm pleased to have the opportunity to emphasise them, to re-emphasise them now. Of course I give way.
Thank the Minister for giving way. So it's been explained that the grounds for appeal, individual appeals, are exceptionally narrow. Therefore, why is it needed? Why are 150 judges needed if the grounds for appeal are exceptionally narrow?
As I said in response to my previous intervention, they are being stood up in relation to the Illegal Migration Act that was taken through by my right honourable friends, the member for Fareham and for Newark, in anticipation of the work that will need to be done. It is sensible governance, dare I say it, but he's right to take me back to the individual claims, because that's what I want to turn to now in the few minutes that I have got left. Because the legislation provides that a court may only grant interim relief where there is a real, imminent and foreseeable risk of serious and irreversible harm. There must be credible evidence of that. There cannot be simply a bare assertion. And Clause 4, Subclause 5, actually cites the Illegal Migration Act, which my right honourable friends took through last summer. And it's worth setting out that within that, within Clause 39, it sets out extremely narrow range of circumstances whereby an individual claim will be made. And I would encourage honourable and right honourable members on both sides to look at Clause 39 of the Illegal Migration Act and just how tightly and just how high the threshold for serious and irreversible harm is. May I just briefly turn to new Clause 6 tabled by honourable members opposite. I was intrigued to hear the Shadow Minister state that the purpose of this clause is to invite further legal challenge. That seems to be, Dame Rosie, Labour's plan, to invite further legal challenge. That's the purpose of new clause being tabled. That is the exact opposite purpose that those on this side of the House have. We want this to work. Yes, of course.
Simply misrepresenting. The purpose of that new Clause 6 is to put the monitoring committee on a statutory basis so that it can potentially be subject to our own domestic courts. I don't know whether he thinks our domestic courts should be lower down the pecking order than the courts of Rwanda.
I'm grateful to him for his intervention. When he was setting the policy out, in his opening he said it will invite further legal challenges. Those on this side want to shut out legal challenges. Those on the side opposite want to encourage further legal challenges. Dame Rosie, the government has delivered a plan for immigration that will work. This builds upon the excellent work of my right honourable friend, the member for Witham, the champion of the Nationality and Borders Act 2022. It builds on the work of my predecessors, my right honourable friends, the members for Newark and for Fareham, who worked incredibly hard to deliver the long-awaited Illegal Migration Act, the toughest piece of immigration legislation until this piece of immigration. Just look at Albania. Dame Rosie, our successful deal with Albania started with small numbers, has now removed nearly 6,000 people with no right to be there. We know that the deterrence has worked because small boat arrivals from Albania are down by 94%. Legal challenges have not successfully stopped the flights to Albania. Flights have not been stopped. In fact, not a single case of Albanian small boat arrivals has reached a substantive hearing at the upper tribunal in the past year. Those on this side of the House are united in our determination to make sure this bill works. As drafted, it creates an ever tighter test that illegal migrants face removals to than they face removals to Albania. Our Rwanda Bill is tougher, tighter, it goes further. We have a plan to stop the boats, and I invite honourable members to back it.
Alison Thulis.
Thank you very much, Dame Rosie. And what a despondent, pathetic, ridiculous bill this has been, and what a grim debate it has been to listen to. We have had a wide range of speeches. Most of them, I'm afraid to say, putting it politely, were absolute guff. The UK is not looking to accommodate 8 billion people. Of course it's not. Most people in small boats are not economic migrants. We know this because the Home Office grant them asylum. Absolutely. The only member, I believe, that mentioned the people that this bill will affect was the honourable member, my honourable friend from Sheffield Hallam, who talked about the impact that this will have on real people, on their lives, on their futures, and the impact that this legislation will have. None of the members opposite, as far as I can establish, have ever met or spoken to an asylum seeker, have any conception for the struggles that they have been through, because they weren't able to quote a single one that they have sat opposite in their surgeries. Asylum seekers have done them no personal harm, yet they seek to ruin their lives. And even to make it light for a second, Dame Rosie, my honourable friend from Inverclyde, who ended up being crocked at the refugee football tournament that he played in, he doesn't bear any ill will to the asylum seekers who played in that game. He bears the ill will, I think, mostly to me for forcing him to play in that. It was not the asylum seekers and refugees whose silky skills outclassed us on the football pitch, and I would encourage members who want to learn a little bit more to sign up for the refugee football tournament, which will be coming up before we know it. Dame Rosie, UNHCR don't buy the government's assurances. They have been very, very clear that nothing that has been said or done has changed the situation. They say that the Rwanda Partnership Treaty is not compatible with international refugee law. They say that we cannot declare Rwanda a safe country in perpetuity. And I don't believe we should be declaring any country, really, a safe country in perpetuity, as my honourable friend from Western Berkshire said in relation to India, where Jagtar Singh Johal is still being held in arbitrary detention from no effort from this government to see justice done for Jagtar. Dame Rosie, this scheme fails in many, many respects. It's an affront to human rights. It's an affront to the dignity of individuals and human beings. It's an affront to the international obligations that this government has claimed that it holds dear when it asks other countries to abide by international conventions and rules, yet undermines them themselves when it suits them to do so. There's a practicality issue as well. The Independent have just published some figures which the House may find interesting. Over the past 5 years, Rwanda have only assessed 421 total asylum cases, and they have refused 2/3 of those cases. Many of those people from Afghanistan and Syria who have an indisputable case for their asylum claims to be heard. We know that Rwanda has form in not upholding its obligations to Israel when they had a deal with them, and nobody has given any case to say that anything has changed from the Supreme Court ruling last year on this issue. And in any event, on the issue of deterrent, which many members opposite have mentioned. 70,000 people have crossed the Channel since the Rwanda deal was signed. If it was any kind of deterrent, that would have had some kind of effect, would it not? That has not happened. And in any event, this government only seeks to remove a couple of hundred people from that 70,000 to Rwanda. They are absolutely incompetent in bringing this before us today. It is a toxic distraction from a failing Home Office and a failing government. They should do the work. They should process the cases. They should give refugees and asylum seekers the dignity and the safety that they so richly deserve. Thank you.
The question is that Amendment 45 be made. As many as are of that opinion say aye. Aye. Contrary, no. No. Division, clear the lobby. The question is that Amendment 45 be made. As many as are of that opinion say aye. Contrary, no. Tell us for the ayes, Peter Grant and Gavin Newlands. Tell us for the noes, Mark Fletcher and Robert Largan. the doors. Order. Order.
The ayes to the right, 66. The noes to the left, 337.
Thank you. The ayes to the right, 66. The noes to the left, 337. So the noes have it. The noes have it. Unlock. We now come to Amendment 10, which has been selected for separate decision. Sir William Cash to move formally.
I have nothing more to say except I beg to move.
Good, good. The question is that Amendment 10 be made. As many as are of that opinion say aye. Aye. The contrary, no. No. Division, clear the lobby. question is that Amendment 10 be made. As many as are of that opinion say aye. Contrary, no.
No.
Tellers for the ayes, Sir Jacob Rees-Mogg and Miriam Cates. Tellers for the noes, Mark Fletcher and Robert Larden. Lock the doors. Order.
The ayes to the right, 68. The noes to the left, 529.
Order. The ayes to the right, 68. The noes to the left, 529. So the noes have it, the noes have it. Unlock. The question is that Clause 2 stand part of the bill. As many as are of that opinion say aye. Aye. The contrary, no. Division, clear the lobby. The question is that Clause 2 stand part of the bill. As many as are of that opinion say aye. Aye. The contrary, no. Tellers for the ayes, Mark Fletcher and Robert Largan. Tellers for the noes, Peter Grant and Gavin Newlands. doors.
Tomorrow at 5. Sorry.
Order! Order.
The ayes to the right, 331. The noes to the left, 262.
The ayes to the right, 331. The noes to the left, 262. So the ayes have it, the ayes have it. Unlock. We now come to Clause 4, to which Amendment 19 has been selected for separate decision. Robert Jenrick to move formally. The question is that Amendment 19 be made. As many as are of that opinion say aye. Aye. Contrary, no. As many as are of that opinion say aye. Contrary, no. Tellers for the ayes, Sir Jacob Rees-Mogg and Miriam Cates. Tellers for the noes, Mark Fletcher and Robert Love. Lock the doors. Order. Order.
The ayes to the right, 58. The noes to the left, 525.
The ayes to the right, 58. The noes to the left, 525. So the noes have it, the noes have it. Unlock. The question is that Clause 4 stand part of the bill. As many as are of that opinion say aye. Aye. The contrary, no. Division, clear the lobby. Question is that Clause 4 stand part of the bill. As many as are of that opinion say aye. Aye. Contrary, no. Tellers for the ayes, Mark Fletcher and Robert Largan. Tellers for the noes, Peter Grant and Gavin Newland. doors. Order. Order.
The ayes to the right, 330. The noes to the left, 55.
The ayes to the right, 330. The noes to the left, 55. So the ayes have it, the ayes have it. Unlock. We now come to new clause 6. Stephen Kinnock to move.
Changes to the classification of Rwanda as safe.
The question is that new clause 6 be read a second time. As many as are of that opinion say aye. Aye. Contrary, no. No! Division, clear the lobby. Read a second time. As many as are of that opinion say aye. Contrary, no. No. Tellers for the ayes, Tonya Antoniazzi and Gerald Jones. Tellers for the noes, Mark Fletcher and Robert Largan. Lock the doors. Order. Order.
The ayes to the right, 262. The noes to the left, 336.
The ayes to the right, 262. The noes to the left, 336. So the noes have it, the noes have it. Unlock. Order. Order. That concludes day one of committee on the bill. Whip to report.
I beg leave to report that the committee has made progress and asks leave to sit again.
Committee to sit again what day?
Tomorrow.
Tomorrow. Thank you. We now come to motion number 3 on immigration. Minister to move.
I beg to move.
The question is, as on the order paper, as many as are of that opinion say aye.
Aye.
The contrary, no. The division is deferred until tomorrow. We now come to motion number 4 on immigration. Minister to move.
I beg to move.
The question is, as on the order paper, as many as are of that opinion say aye.
Aye.
Contrary, no.
Aye.
The division is deferred until tomorrow. We now come to motion number 5 on council tax. Minister to move.
To move.
The question is, as on the order paper, as many as are of that opinion say aye.
Aye.
The contrary, no. I think the ayes have it. The ayes have it. Petition Martin Day.
Madam Deputy Speaker, I rise to present a petition on behalf of the constituents of Linlithgow and East Falkirk in relation to buy now, pay later products. Now, used correctly, these products can be fantastic. However, 37% of UK adults have used them in the last 12 months, and Citizens Advice have reported an increase in people seeking help as they're turning to them to support themselves through the cost of living crisis. The petitioners therefore request that the House of Commons urge the Government to implement regulation of buy now, pay later products as a matter of urgency to prevent any more people falling into serious and unmanageable levels of debt, and the petitioners remain, etc.
Petition, buy now, pay later products.
Petition Richard Ford.
Thank you, Madam Deputy Speaker. And I rise to present a petition on behalf of the residents of the Axe Valley, of the towns of Seaton, of Beer, of Colliford and the surrounding area, who are objecting in the strongest possible terms to the disposal of an entire wing of Seaton Community Hospital. This petition has been signed by over 9,000 of my constituents because they object to the fact that this hospital that was funded by generous local donations is being ripped away from them and in part potentially sold off by NHS Property Services and disposed of for potential sale for housing. The petitioners therefore request that the House of Commons urge the Government to take into account the concerns of the petitioners and take action to return the facility to the local community so that it can be repurposed to provide better care for those living in the area.
Petition, community hospitals.
Thank you, Madam Deputy Speaker. I rise to present a petition on behalf of the residents of the constituency of North Ayrshire and Arran, who are deeply concerned about the ongoing industrial dispute at Defence Equipment and Support in Beith, North Ayrshire, an arm's-length body of the Ministry of Defence. The strike for improved pay and conditions is unprecedented, involving non-craft workers preparing arms for shipment at the depot, who face discrimination in the payment of bonuses to workers, and the petitioners are concerned that these bonuses are withheld from workers earning less than £21,000 per year and have been excluded from retention bonuses and stands with the workers in rejecting a two-tier workforce. The petitioners therefore request that the House of Commons urge the Government to take into account the concerns of the petitioners and urgently review and intervene to ensure a fair resolution to the industrial dispute. And the petitioners, etc.
Petition, Defence Equipment and Support Site in Beith.
The question is that this House do now adjourn. Wendy Chamberlain.
Thank you, Madam Deputy Speaker. There are 2 million older people living in poverty, and that is 1 in 6. And another million are sitting just above the poverty line, silently struggling to make ends meet. And together, a quarter of older people are in or are at risk of being in poverty. And during recent years, the phrase heating or eating has become shorthand for the cost of living crisis. It rhymes and it's easy to say, but this is the reality that is facing too many of our pensioners. Age UK research found that 4.2 million people cut back on food or groceries last year, whilst a survey by this House's Petitions Committee of those engaging in petitions on pensions levels found that 3/4 were worried about affording food. Now, health statistics always worsen in the cold winter months, with mortality rising in all parts of the UK last year compared to previously. And as we face an even colder winter, in my constituency of North East Fife, we are often reaching minus temperatures overnight. There are very real consequences when older people can't afford to properly heat their homes. The reality, Madam Deputy Speaker, is that heating or eating is not a catchphrase. It's a decision about survival, and it is our duty as policymakers in this place to ask why this is a reality for so many of our older people and to find solutions for this. Now, Madam Deputy Speaker, I welcomed the Government's eventual decision to keep the triple lock this year, but the lack of clarity and uncertainty about that decision did appear to be electorally motivated, and I would argue caused a great deal of anxiety for many older constituents.
Will the honourable member give way?
Happy to give way to my honourable friend.
I'm grateful to the honourable member who is talking about the triple lock on pensions. I've heard it said in this House just in recent months that the triple lock on pensions was a Conservative proposal. So I went to the library to find out if that was true. I've got here the 2010 manifesto, which talks about restoring the link between the state pension and earnings, and the 2010 Liberal Democrat manifesto, which talks about uprating the state pension annually by whichever is the higher of growth in earnings, prices, or 2.5%. Does she agree with me that it was a Lib Dem proposal?
I'm grateful to my honourable friend for that intervention. I meet regularly with Steve Webb, the former Lib Dem Pensions Minister from the Coalition, and I know how hard he worked when he was in government on this policy, so I entirely agree with him. I thank him for his intervention. The triple lock is no use to anyone, though, Madam Deputy Speaker, if the Government can't get its systems working in order to pay people what they are due. And repeatedly last year, we learnt of pensioners nearing or reaching pension age, trying to top up their national insurance records and seeing their money disappear without a trace. It would appear again some weeks later, but only often after chasing by an MP, an advisor or by media coverage. And, Madam Deputy Speaker, this wasn't just one or two cases. What became apparent were systematic problems of jammed helplines and hundreds upon hundreds of people losing track of their savings as they paid them over to the Government. So can I ask the Minister in his response to tell us what he is doing to properly resource the future pension centre? I'm grateful to give way.
Sorry, thank you very much. I thank the honourable member for giving me. She's making a very strong point and a very excellent speech. But on that point of savings and topping up national insurance, we are hearing that something like 2/3 of those over the age of 64 are dipping into their savings just to keep going. They're cutting down on their food and they're eating less healthily. Apart from the cruelty we're showing to pensioners and forcing them into this position, is the Government not being short-sighted and not seeing the implications for the NHS, the welfare system, social care of treating our pensioners so badly?
I'm grateful to my honourable friend for giving way. I think this is reflective across a number of policy areas, that sufficiency of income and allowing people to live with dignity and respect and knowing that they can cover the essentials is something that we should be looking to do for all of our services and for pensioners as well as other age groups too.
Further to that point.
I'm grateful to give way to the honourable member for Strangford. It's not an adjournment debate with it.
Madam Deputy Speaker, I wish to congratulate the honourable lady for North East Fife. She always brings things to this House and to the Westminster Hall, things which are bread and butter issues which I support. I'm glad to come along and add my support to the honourable lady tonight. The price of electricity rising in Northern Ireland by 20%, pensions rising only by 8.5%, similar increase in the cost of meat and veg. It's clear that those comfortable on their pension in 2020 will be substantially less comfortable now. Does the honourable lady not agree that an investigation into energy prices must take place, as currently people feel they're being gouged every time they put on their light or gas, and feel the pain of prioritising one necessity